Welcome to the fourth hearing of the Committee's inquiry into Budget Estimates 2023-24. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Robert Borsak and I am the Chair of the Committee. I welcome Attorney General Daley and accompanying officials to this hearing. Today the Committee will examine the proposed expenditure for the portfolio of Attorney General. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and thank you for making the time to give evidence today. All witnesses will be sworn prior to giving evidence. Attorney General, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. I would also like to remind Mr Tidball, Ms Campbell and Mr Thomas that you do not need to be sworn, as you have been sworn at an earlier budget estimates hearing before this committee. For all other witnesses, could you please state your name and position title and swear either an oath or affirmation? And please begin with the witness to my left. Ms Hitter.
Thank you very much, Chair. My name is Monique Hitter. I am the CEO.
You might just pull the mic a little closer and talk. Don't be afraid to shout into it.
Thank you, Chair. My name is Monique Hitter. I am the CEO of Legal Aid New South Wales. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Mr McKnight.
I'm Paul McKnight. I'm the Deputy Secretary of Law Reform and Legal Services at the Department of Communities and Justice. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Okay, thank you. Today's hearing will be conducted from 9:15 to 5:30 p.m. We are joined by the Minister for the morning session from 9:15 a.m. till 1 p.m. with a 15-minute break at 11 a.m. In the afternoon, we will hear from the departmental witnesses from 2 p.m. to 5:30 p.m. with a 15-minute break at 3:30. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for the government questioning at 10:45 a.m, 12:45 and 5:15. We will begin with questions from the opposition.
Thank you. Good morning and thank you, Attorney, for being here. And can I say how delighted I am to welcome someone from your excellent educational background, the best law course in New South Wales. So
Australia.
In Australia, yes, of course. Perhaps
point of order. I take the point of order. That's a quick one. That one. We're getting off to the wrong footing here. Come on.
Okay. So, big portfolio, a lot of activity, but let's just start with some housekeeping. In relation to DLO secondments in your office, have you or your office ever requested specific public servants to fill DLO positions?
No, I have 5 DLOs, correct me if I'm wrong, Mr Tidball. They have been selected by the department. They have undergone a selection process for suitability for work within the department. We had no input into their appointment.
Thank you.
The department sent them down and they're excellent people and very
Thank you.
good
And
public,
can you
very good public
confirm
servants.
that those DLOs, while seconded in your office, have not undertaken work that would contravene the Cabinet Memorandum?
I wouldn't expect so.
So that's no?
That's no.
Great, thank you very much. Can I now take you to the amendments to the Fines Act, which will facilitate the introduction of your drug diversion scheme? Given its similarity to the ACT policy, are you concerned that there will be a similar effect on road deaths when it's introduced?
On road deaths?
Yes, if you remember the testimony that was given on Tuesday by the New South Wales Police Commissioner, that the biggest contributor to road fatalities in New South Wales is speed, whereas in the ACT, and I quote, 70% of fatal accidents were drug-related. Was this considered as a factor in your decision to implement this new policy?
I can't foresee what might happen in that regard, but I do note that the cannabis cautioning scheme, which operates on a similar basis, has been operational for 20 years now. The scheme that we've introduced as well is one that gives police discretion as to whether they want to exercise to issue a SIN. And so I imagine that the police will look at the offender or potential offender that they're dealing with and make an assessment as to whether they're suitable.
I suppose
for
the
that.
issue, Mr Attorney, is the policy impact that this will have on road fatalities, and learning from the ACT experience of 70% of road fatalities being drug-related. And I note that your diary indicates one meeting with the Police Association, one meeting with the Police Minister about sexual assault law reform, but no meetings with the Police Minister or senior police to discuss drugs policy. Did you get their advice about the likely impact on road deaths before deciding to proceed with your new drugs policy?
We have very strong laws against drug driving, and we have random drug driving tests.
Oh,
as
no,
well.
that's not my question, Mr Attorney. The question is, did you seek advice from the police, especially with respect to the ACT experience, about the likely impact of your drugs policy on an increase in road fatalities or drug-related deaths becoming more significant on our New South Wales roads?
Well, when you say our drugs policy, it's actually the former government's drugs policy. And so...
I think there are differences between the two policies, and we will explore those.
They're not. What we've done is to implement the policy that was in train under the former government, and I have to say...
So the answer then is that you haven't actually got
Please
advice from the police?
don't interrupt me. The Chief Medical Officer was the one that put this policy together after consultation across government, and I assume that they would have taken all of those relevant considerations into consideration.
So your answer then is that if we want to know the police input, we should speak to the Chief Medical Officer about whether police input was sought into this policy. Is that your answer?
I imagine that you would have asked the Police Minister about those things the other day.
Thank you. And in respect to the drug policy, what drugs will be included in your scheme?
All drugs in Schedule 2, I think, of the Drug Misuse and Trafficking Act, with the exception of cannabis.
Okay.
And
so
can I just note?
Yes.
Small quantities only.
Yes. So you're saying all drugs, heroin?
As I understand it, yes.
Yes. Ice?
Yes.
So you think all drugs should be treated the same?
It was a partnership between New South Wales and the police force. That's the advice.
Yes.
That's their advice. So it's their considerations that we have adopted.
Ketamine, GHP, will they be on the list of approved drugs?
Well, they were when your government was in power, and that was the scheme that you put in play, which
and
we've
you're
adopted.
aware these are commonly used as date rape drugs?
Look, don't ask me for my view on whether they are commonly used or not. Those statistics will be available for you to have regard to elsewhere.
But you're aware that that is a use of those drugs?
It can be, yes.
Great. Thank you very much. Your press release of 10th of October indicates that your new drugs policy will apply for, and I quote, small quantity drug possession offences. What exactly is a small quantity?
It varies from drug to drug, so you'll have to have a look at, it is Schedule 2, I think, of the Drug Misuse and Trafficking Act, which treats each substance differently depending on its strength and danger, and quantities vary.
Perhaps you could provide examples of exactly where these quantities are listed, because the only details we have is your press release, which is 760 words long, which doesn't give us details of which drugs and which quantities.
And my second reading speech, which is quite a bit longer than that as well.
Okay, so in your second reading speech, did you look at, I don't know, is it 10 lines of coke? Is that a small quantity?
I need a scale to work out how big 10 lines of coke are. Having never actually ever seen a line of coke, you're asking the wrong person.
Well, these are important questions,
They
though,
are.
for the people of New South
Yes, they
Wales
are.
to understand what the limits are and therefore what the law... In fact, this is a question, Mr Attorney General, that goes to rule of law, because in a society ordered by the rule of law, everybody has to know exactly what the law is, and this new law seems to be quite obscure at the moment.
No, it's not. If you open up the Drug Misuse and Trafficking Act, you can see it quite clearly.
It's a press release, is the policy.
No,
it's a
no,
press release
no.
because, as your amendments to the Fines Act made clear, you are not amending the Drugs Misuse and Trafficking Act. It's a press release and one change. And I am just simply asking for more details for the people of New
Press
South
release
Wales.
is not legislation. So it's Schedule 1, is it?
Mm-hmm.
Schedule 1.
Will there be an education campaign about your new drugs policy, especially for border communities like Queanbeyan and Goulburn, about the similarities and differences between the ACT and New South Wales drug laws?
I'm not sure because this has been driven as a partnership between police and New South Wales Health.
So I'm sorry,
I'm
you're
just
saying
seeking-
it's
I'm
a
seeking-
partnership
I'm seeking
between
some
police and New
advice.
South Wales Health, so the Attorney General's Department isn't
I'm
involved?
seeking some advice. Let me answer the question.
I think, can we take on notice the details of the public education involved in this process, and we can perhaps give that to the committee afterwards.
Yes, but very happy to take that on notice. Look, can I just confirm that the permitted carry amount for cocaine is 1 gram?
I think that's correct, yes.
Therapeutic Guidelines, a clinical resource for Australian medical practitioners, says that cocaine exposures of 1 gram are potentially lethal. Minister, do you believe that the system of waiving fines for possession and use of 1 gram of cocaine is the best way to achieve health outcomes for the community?
The best way to achieve health outcomes is to get people into health, drug and alcohol programs, and that's what this program seeks to do.
But you're happy with the 1 gram limit, given the therapeutic guidelines
It's not
warning?
a matter of whether I'm happy or not. We're acting on the advice of the Chief Medical Officer and the police and adopting the existing quantities in the Drug Misuse and Trafficking Act, which have been in situ for quite some time.
So you did get advice from the police in relation to this policy?
They wrote
And
they
that
wrote
advice
the policy.
included possible impacts on the road toll?
I'll have to take that on notice. I don't have
That would
I
be,
don't
I
have the
would
paper in
appreciate
front
that
of
if
me.
you could take that on notice. Thank you. Minister, are there currently sufficient diversion programs in place to support all those who may be eligible for your new drugs program?
Sorry, I don't understand what you mean.
Well, the program that's being introduced would see all those in possession of a small quantity of any drug offered a diversion in lieu of payment
not
of the
offered.
fine.
They're not offered
Are there
one.
sufficient facilities in place to provide diversions for all of those people who will be found to be in possession of a small quantity
So
of drugs?
the advice from the police and commissioner and the chief medical officer is that they will be ready to implement that scheme on the ground within 6 months.
So it will be ready. So there are not currently, but there will be sufficient diversions in place within 6 months.
That's my advice from the chief medical officer, yes.
What's the start date of the program?
6 months from the date that it went through Parliament, I think, or from when it was
Well,
proclaimed.
sorry, I think the issue is it didn't go through Parliament. There was an amendment to the Fines Act and a press release. So are you saying it will be introduced 6 months from the 10th of October, the date of the press release?
I'll check exactly what the mechanism is, but
Thank
So
you.
the program is to be implemented early next year.
Early next year when?
We
1st
don't
of
have a
January?
specific date.
Sorry?
We don't have a specific date yet.
When will you be able to share the details of the date with the people of New South Wales?
I can take on notice the question of how much detail we can provide you about implementation at this point. There's a range of implementation action going on within police and health and within state revenue, as you might imagine.
I understand that, but you would also understand surely that it is an important matter of transparency, the date at which a really significant change comes into effect, and the importance of the people of New South Wales being aware of that date.
and there'll be plenty of notice given.
There will be plenty of notice given?
Yes.
Okay, thank you very much. You've referred, Mr Attorney General, to our diversion policy, which was to be supported by an investment of $500 million, and this included almost $360 million for targeted AOD health diversion initiatives to address what you have identified as a currently existing gap in treatment, which is why you're doing this implementation work. However, when we look at the detailed breakdown of your plans, it shows an investment of almost $30 million less than we were going to make. What programs have you cut?
I think that's probably better directed to the Health Department or the Minister for Health. The rollout of the program is, as I understand it, a matter for the Minister for Health.
So you're saying you can't answer what
I'll
programs are
take
being
it on
cut?
notice, but I think it probably would have better been addressed to the Minister for Health.
And Coalition Policy announced that our almost $360 million in health supports would create 670 new jobs, with 63% being in rural and regional areas. Are you cutting investment in rural and regional areas?
I think I refer you to my previous answer.
So you're saying that this is not a justice program. This is drugs, this is police, and you're saying it's not a justice program?
Did I say that? When did I say that?
When you said that these are questions that need to be answered by the Health
The
Minister.
specific details of the rollout, yes.
So it's a justice program, but for details we have to go to the Health Minister. Is that the answer I'm getting?
For the rollout, it's my understanding, yes. Of the diversion programs, the drug and alcohol programs, yes.
So let's just do a role play. I'm arrested with a gram of coke, and I'm offered I see members of the opposition laughing, and I am happy that they regard
Can we
that.
have more role play? Like, that's the Greens party.
And I am
never seen a
offered
line of
a court infringement notice, and it's in
I've never seen
6,
one.
7, 8
And I
whenever
don't wanna
this
come
policy is
against it, up
introduced
against
time, and I am offered
I'm
a
talking real
diversion
ones.
As in order instead of paying
I don't go to
the
places where that
fines.
happens. I'm boring, sorry.
That diversion is the penalty for the criminal offence that I will have
Thank you.
committed. Why is the rollout of how those diversions will be managed not a justice matter and a health matter?
Well, who said it's not a justice matter?
Attorney, with respect,
You're
you.
using your own words. I didn't say it's not a justice matter.
But you can't give us details of the diversions. The diversions are in lieu of a criminal penalty. They are a justice measure as much as a health measure.
Well, they're actually a health measure. And if they're completed...
So is your answer, Mr Attorney, that for the first 2 offences there will be no justice penalties, there will be no offences, it will be all health, and the justice system is not involved with drug possession for the first 2 times? Is that your policy, Mr Attorney General?
The policy is the policy that we've announced, and it's all in my second reading speech.
And with respect,
Hold
it's
on,
very
Ms. Carter.
opaque.
Please don't interrupt me. I don't interrupt you, so be courteous. For the first, if the diversion programs are completed, the fine will be waived. That's the answer. So they are diverted into drug and alcohol programs and treated as a health measure for a maximum of 2 times for a low-level drug offence.
So the diversion is a precursor or a necessary precondition of not having to pay the fine. So therefore it is under the purview of the justice system. It may be offered in conjunction with the health system. And so I would expect that we would have details of implementation available from the justice portfolio.
Except the drug and alcohol diversion programs don't live within the justice portfolio, they live within the health portfolio. They've been delivered by New South Wales Health. I don't understand what is so unclear about that.
In your press release, you said that we want to see people receive the health supports they need rather than see them caught up in the criminal justice system. What did you mean by health supports when you said that? What exactly will a drug diversion look like?
So New South Wales Health has designed an alcohol and other drug intervention to match the needs of criminal infringement notice recipients. The health intervention is well within the scope of practice for qualified and skilled alcohol and other drug specialist providers. New South Wales Health has designed an escalating health response that has been endorsed by the Chief Health Officer to ensure that the health intervention proposed matches the need of the person it applies to. Every interaction with a health professional decreases the likelihood that people detected with minor quantities of drugs will fall through the gaps in care or not be able to access health interventions which could prevent further drug misuse.
Thank you. I've read the press release. What I was asking
wasn't
was
on the
what
press
would a
release.
health intervention look like? Perhaps we can turn to the words of Dr. Kerry Chant in budget estimates on the 26th of October, who said that this intervention, and I quote, may be all the way through from a brief intervention to a discussion where there may be a recognition that the drug and alcohol issue is affecting the person's life and that they would be appropriate for residential rehab. What do you understand to be a brief intervention?
They're Kerry Chant's words, so you should have explored those expressions with her while you had the chance.
So you're telling me that you don't have any concept of what the interventions that are offered as part of this offence program will look like?
I didn't say that.
Well, then tell me, what will the intervention look like?
It'll be as the health department intends it to be.
Will there be a telehealth component to this, or will it all be face-to-face?
As I understand it, will be telehealth components.
And if I'm in Broken Hill, will I have the option of face-to-face or telehealth?
As I understand it, they'll be both. Both of them will be telehealth.
If I'm in Barorona, there'll be telehealth or face-to-face?
You could have asked Kerry Chantle this, Ms Carter.
I know, but I'm asking you.
Well, the program's been rolled out by the health department, so they're the ones who have the knowledge of what it entails in detail. But my understanding is that there'll be telehealth or telephone calls.
As the First Law Officer, are you not concerned that the options for anybody who receives a criminal infringement notice are not the same at every place in New South Wales? Because the rule of law requires that everybody is treated equally before the law. And if the options in Bourke are different to the options in Bankstown, if there's telehealth in one place and face-to-face in another, if there's a 3-month wait for a rehab bed in Bourke, but a 1-week wait for a rehab bed in Bankstown, and if that is part of the intervention, does that difference not constitute a major impact on the operation of the rule of law in New South Wales?
I'm not sure I agree with that characterisation. What's available to all citizens is an opportunity to have an intervention program. And if you're asking me, and you're assuming that the way you've characterised the services available to people will be so, and I'm not sure you're correct. And in any event, these are questions you can put to the Health Minister or to me on notice, and I'll try and get the advice from Health, but they're not being delivered by DCJ. Those programs have been delivered by Health.
It is a joint program. It is health and justice. And the justice
There's
implications...
a justice framework around it with health interventions at the core of it, and they've been delivered by different entities within government.
And is not the role of justice to ensure that the health interventions are being delivered in a way that there are equal opportunities for intervention for every citizen in New South Wales, and you're not going to get a different intervention according to your postcode?
Well, I would assume that that's the way the program's been delivered, yes.
Is an assumption strong enough, Mr Attorney, or should you have investigated and be confident and certain that this is the way in which this program will be delivered?
I've trusted the advice of senior health and police officials.
So you've sought advice about this issue
I've
then?
trusted the advice when they...
Well, how can you trust advice you haven't sought?
I assume when someone like Kerry Champ puts together a drug
So
and alcohol
you've assumed that people have given you advice that you've trusted, but you have not asked the question about equal application of this program to every citizen in New South Wales.
No, the question hasn't arisen in my mind because the literature I've read on it says that the program will be delivered via telephone and telehealth programs. So unless you're someone who doesn't have access to a telephone or any telehealth, the programs will be equally delivered across the state. That's my understanding.
Thank you. My time's expired.
Thank you. Crossbench.
Thank you. Attorney, were you pleased to see the result in the GLJ case?
Was I pleased to see it? Oh, I don't think that's the right question to be asking me as the First Law Officer. I realise the destruction that's been brought upon way too many people over way too long in relation to sexual offences like that. But I also note some of the advice from the Royal Commission about permanent stays. And I don't think it's appropriate for me to say whether I'm pleased or not with the delivery of a judgment from the High Court. It is
So
what
do you
it is.
so do you welcome the fact that now some of those victims may be able to continue on their path to justice?
Yes, they'll be greatly pleased, and if there are instances where justice is denied because of permanent stays and the High Court judgment corrects that injustice, yes, that's a good thing for everybody.
And so what steps are you now taking? Are you taking any steps to amend this part of the law?
Yeah, so what we're doing, Ms Higginson, is to take our time to have a look at what the implications of GLJ are. And
Sorry, when you say you're taking your time,
well, okay, I've asked, as soon as immediately upon learning of what the High Court had handed down that judgment, I instructed these good people sitting at this table to go away and prepare a brief for me on its effect and its implications, and what action it might require me to take, or the New South Wales government to take.
and have you received that brief?
No, I haven't yet. No.
Okay. And so are you planning to, so when you've received that brief and in the meantime, are you working with or are you planning to work with the relevant stakeholders, including the legal experts and the advocacy groups and the survivor support organisations, to work out what we can do going forward?
Yeah, we'll be ready to do all of that if the advice that comes back is that's needed, if that's required, yes. And we work.
So hang on, Attorney, have you not yet made your own mind, in your own mind, have you not already assessed that something really significant has been going terribly wrong for a sustained period of time? We've now seen a crack in the wall that's been denying victim survivors access to justice, and you're not already saying, right, we can move forward with all of these victim survivors, and you don't yet have a plan in your mind as to what that would look like?
No, I'll wait until I get the advice on what the implications of GLJ are.
So you don't yet understand what those implications are, even in principle, and let alone the operation of what that would mean?
I've had a brief read of the judgment, but I'm waiting for the department to return considered advice, and then I will see what that advice says.
So would it be news to you if I said that there are victim survivors that have been denied justice for a sustained period of time? There are victim survivors who have had to be forced into inadequate settlements because of the fear and the advice from their lawyers that they'll be subject to stays if they carry on, and that they are now literally sitting in a system that has denied them access to justice. Does that surprise you to learn that?
So I didn't understand the first part of the question. It was such a long question.
Well, it really wasn't. I'm just setting out some. I'm just setting out.
Do you understand? Is that what the question was?
Do you? I said, would you be surprised to learn that they are the facts out there?
I understand that there are people in that position. Yes.
Right. And so my question is, you are the first law officer. That right now, you're waiting for a brief. A decision was handed down some weeks ago, few weeks ago. It's a major change, a major, significant change in the legal landscape in New South Wales for victim survivors of some of the most heinous
Point of order.
offences.
My point of order is this a German speech or question? I mean,
The attorney asked for clarification about my question. I'm providing it. That's to the point of order.
Yeah, there is no point of order.
Yeah, thank you. So these are the facts, is that right? Or do you agree, attorney, that that's what's happening in New South Wales right now?
I'm not going to move towards legislating in something as monumentally important as this.
Excuse me, attorney.
No,
I accept that.
Excuse me. Let me
Sorry.
finish.
Can I just?
Sorry.
This is not the question. This was not the question, attorney.
Please don't interrupt me when I'm answering.
This was
I'm
not my
5
question.
seconds into the answer, Ms.
Excuse me,
Higginson.
attorney. In budgets,
so
I
will
have the
not be
capacity to
moving.
redirect the witness, and
Yeah.
I'm doing that now.
And
if that's
I've got
okay.
the capacity to insist that, having been 10 seconds into my answer, you allow me the courtesy of finishing what I'm saying. And I will not be moving into legislation
You've already
in
answered
such
that,
a
and I understand.
monumentally
You're waiting
important
for the
area
brief.
of law until I get
The brief.
advice from
I
the
understand.
department. Yes.
I am not questioning you about your legislative intent. I understand, and you provided an answer, that you're waiting for a brief. I understand that's the way it would work responsibly. I'm actually asking you now about what you're doing in relation to working with advocacy groups, legal experts and survivor support organisations. Have you met with them? Have you opened your door to say, I'm getting a brief prepared? Have you got any input right now into this situation?
Not in the time since the GLJ has been handed down, no.
So since the decision, is this one of your priorities as Attorney General?
I'm waiting for the brief. I can't be any clearer than that. When I get the brief, we will know what the lay of the land is, and I'll be directed towards future action on an educated basis.
And so, in terms of the victim survivors that have had to settle for compromised settlements, is that going to be part of your brief? Have you considered that component, or are you just looking at what will happen for people who are currently subject to stays?
When I'm advised as to what the full ramification of the High Court's decision is, I'll be better able to make those decisions. And I'm not trying to escape questioning on this, and I understand that you've been a passionate advocate, and then there are many, many thousands of victims and advocates across the country who are waiting with bated breath to see what happens next. And I understand the gravity of that, and that's why we'll treat the advice and this issue with all due seriousness, Ms Higginson.
And so what's your timing? When the victim survivors that I've been talking to, what can I suggest to them about, and including the ones who have had to be subjected to compromised settlements, what should I tell them about the timing the AG's department and the AG's considering?
I'll tell them now that I'll act with no delay, no undue delay.
I understand but what does that mean for those people? What is undue?
This is too important a decision for me to speculate.
So
when
is the date that you'll be receiving your brief and your advice?
When the department properly considers it and hands it to me.
And how long would that normally take in such a circumstance, of which we have never really seen before?
I'm happy to take that on notice.
Thank you. So you will get back to us with a time frame?
Yes.
Thank you, Attorney. But can I just... do you, as the Attorney General, the first officer of this state, see and that you have considered that this is an incredibly significant decision and that it may be appropriate to already start engaging with those people who are going to be looking for your guidance to help them through the next steps?
I don't know that it would be appropriate to start engaging with them.
So how are you going to understand the
breadth? It may raise
breadth?
Expectations that something's going to happen, where it might not. So you're asking me to speculate about what future actions might be, and to sit down with these poor, long-suffering people and say to them that I'm going to look at a judgment, but I don't know what the ramifications of it might be. I think that would be a bit cruel to do that as well. I don't want to act hastily here. This is hugely important, Ms Higginson.
I'm just struggling with the notion that you can see, I think, a grave injustice because of our incorrectly applied legal system, that it's happened over a sustained period of time. Victim survivors have been denied access to justice, and I can't quite yet hear that first order of principle that, right, now we know there is a pathway to justice, the state will assist you. Is that your approach? Is that your forward face on this?
I don't know how many times I can restate my intentions here, Ms Higginson. As much as you want to keep drawing me out with different words, and I understand you're passionate about this, I don't see that I can answer that question any differently than I have this morning.
So you don't see it then as your job to be walking forward with victim survivors who've been denied access to justice, to walk with them on a pathway to justice. You don't see that as your job.
The pathway I walk will be dictated by what the nature of the High Court's decision is and the advice that I receive from the department in respect of it. And I can't see that you would expect me to conduct myself in any other way, frankly. It would be imprudent of me to do that, and possibly
Well, I
cruel.
think, yeah, I mean, I do. I sort of think that many people in this state actually expect the Attorney General to be a champion for justice. And when the High Court, the highest court in this country, makes it very clear that access to justice has been denied through a perverse application of laws such as these stays, and that the High Court has said the door is open now for those victim survivors, I thought that you would think that you can now champion a path to justice.
Is that a question or a statement?
Does it matter?
It's what I want it to be, thank you.
Statement.
Attorney, moving on. When did the Standing Council of Attorney Generals last meet?
In 22nd of September this year.
Thank you. And was raising the age of criminal responsibility discussed at that meeting?
I wasn't there, Ms Higginson, but I believe it was.
It was.
It was.
Mhm.
Thank you. And so, are you able to tell me that whether or not New South Wales still has a plan, or has a plan to raise the age of criminal responsibility?
So, Ms Higginson, consideration of whether the minimum age of criminal responsibility should be raised is occurring at a national level by the Age of Criminal Responsibility Working Group established by the Standing Council of Attorneys General, which they're currently doing. The New South Wales Government supports the work of the Standing Council of Attorneys General Working Group, and New South Wales is represented on this working group by representatives from the New South Wales Department of Communities and Justice. At the most recent SCAG meeting on 22 September, amongst other things, participants noted the final report of the working group on the services and supports needed to support children diverted from the criminal justice system under a raised minimum age of criminal responsibility. Participants agreed to consider the report and return to the next meeting with a position or update on minimum age of criminal responsibility reform in their jurisdictions. One key consideration for New South Wales in any future decision about raising the minimum age of criminal responsibility will be the existing adequacy of appropriate intervention and support services for young people who would no longer be considered offenders but who would continue to cause harm and impact the community. Any change must ensure that young people and communities are safe and are adequately supported. Additionally, it's important to note that the Young Offenders Act 1997 already sets out a framework for alternative responses to offending behaviour, including warnings, cautions and youth justice conferences. It can be used by police and courts when dealing with children aged between 10 and 17 who commit certain offences. The Act is underpinned by key principles, including that the least restrictive form of sanction is to be applied against a child, and that criminal proceedings are not to
Thank
be
you, Attorney.
instituted
Can I just interrupt you
against
there?
a child
Thank you. I
if
think
there
I
are
get the gist.
alternative and appropriate means of dealing with the matter.
Thank you. I definitely get the gist there. Can I ask why we're still sort of waiting for some kind of national approach when it's really clear there is no national approach and states and territories have gone their own way? Why is New South Wales continuing down a kind of national approach? Like, it's one thing to discuss the matter, but why are we waiting for the national rather than New South Wales forging its own path?
Well, that's been the attitude of the former government. Work is progressing at a national level. It's as is the case with
I'm asking
things
for
like
you.
defamation laws.
Well, what's your
I think
view?
It's always better to be informed by experiences from other states.
No,
and that's what we're
Attorney,
doing.
thank you. But what's your view and why? What are you doing? other than not attending a meeting where something is discussed in the abstract about a national thing that's not happening?
I'm waiting to be informed by work that other states are doing, frankly.
About New South
We're coming off
Wales.
a very low base in New
But,
South Wales.
Attorney, that was about, what you just read out was all about what New South Wales, the issues around New South Wales raising the age. So I'm just asking you, what are you doing about that?
One of the key considerations in raising the age is what happens to young offenders.
Well, Attorney, with respect, we know that.
Hold on, can I answer
No,
the question?
you've just read it out.
No,
We
no.
know that. What are you doing about that?
I was just about to directly answer your question. One of the key considerations in an alternative pathway for when you raise the age is what are the key supports and other elements of an alternative regime that exists to deal with young people if you're not going to incarcerate them. Now, in New South Wales, there's been no work done on this at all. And so I'm keen to see if other states are going to move to this new model, what other interventions and diversionary programs they have, what drug and alcohol programs they have, what residential facilities they might have, and all these sorts of things, because at the moment in New South Wales, no work's been done.
I
And
don't
I'm
think
not
that's
being-
quite the case, Attorney.
Well-
I don't think that's true, actually. I
Okay,
really
then.
don't
Well,
think that's the
well,
case.
we'll
I've
meet-
sat in budget estimates, and the former Attorney General talked about looking at that. They're the things that we would need, those wraparound services.
That's right, and that's the discussion that's
So,
going on
Attorney,
within government
what's your
now.
view at this point in time about raising the age of criminal responsibility?
My view is that you can't raise the age of criminal responsibility unless you've got somewhere to
Attorney,
deal.
do you know how many young
Point of
children?
order.
You can't.
Do you
you
know
can't
how many
raise
people
the
are-
age
Point of
of
order.
criminal
My point of
responsibility.
order is the attorney, or in fact any witness here at this hearing, is entitled to answer the question that has been posed. Talking over the witness without providing them with an opportunity to answer is not consistent with why these hearings are
To the
conducted.
point of order. Thank you. You're wasting time, and I can
Point of order.
redirect.
I'm
Yeah,
not.
I can
I
redirect.
don't take another point
Order,
of order. I'm
order.
not wasting time. But
Order.
if you want to waste time, that's the way it'll end up.
Well, we are wasting time while we argue
Thank you.
about it. But, please allow the attorney a chance to answer the question before asking the next one.
Attorney, do you know how many young people under the age of 14 are currently in incarceration in New South Wales?
So my advice is that between December 21 and December 22, there were 80 proven court appearances, with one aged 10 years old, one aged 11 years.
Sorry, that's not the question I asked, Attorney. Do you know how many young people under the age of 14 are currently incarcerated in New South
I
Wales?
don't have that at my fingertips.
Okay,
I can
that's
certainly
all.
find that for you.
All right. Attorney, do you know the cost right now of keeping one young person under the age of 14 incarcerated per year?
I have heard figures. I don't want to repeat them because I don't know if they're correct at the moment, but we can find out. But it's very expensive, I understand that.
Any ballpark idea of how much it costs?
Well, the last figure I heard was somewhere in the figure of $250,000 a year, but that's years old. So
What if I was to tell you it's $750,000 per year, per child?
if that's correct, I accept it.
And do you think $750,000 could produce and provide some decent wraparound services and support for those young people that we're keeping in prison? If I was to tell you there's 5 children currently in New South Wales being held in custody under the age of 14, and it's costing you and us $750,000 to hold them there, around that, do you think we could be doing better?
Yeah, I do. That's why we're looking into it, yes.
And how long do you think it will take for you to make a decision about whether you're going to raise the age
I
or not?
can't give you a time frame. It won't be sooner rather than later. We're coming off a very low base in New South Wales.
Opposition, questioning?
Mr Daley, you'd agree with me that as Attorney General, you're responsible for the rule of law in New South Wales. That's not a controversial proposition.
Oh, generally speaking,
Yeah, of course. And you'd also agree with me that certainly not beyond the bounds of possibility that when the Premier agreed to light the Opera House sails in the colours of Israel on the 9th of October, that pro-Hamas protests could occur somewhere in Sydney.
could have occurred.
could, possible.
Yeah, there's a possibility
Yeah,
of that.
of course. And in your role as the Chief Legal and Constitutional Advisor of the Crown and the Government of New South Wales, were you briefed on the protests that were expected to take place that night?
No.
No briefing, thank you.
No.
And as Attorney General and as former Police Minister, are you familiar with any situation where conflicting advocates have been allowed to confront each other?
None comes to mind readily, no.
Okay, thank you. So, do you think you should have stepped in to ensure that the confrontation at the Opera House did not occur?
No.
Given your experience in public law and order matters, would you have taken an active role to avoid Jewish people being told to stay away from their own vigil?
Would I have taken an active role in...
To avoid Jewish people being told to stay away from their own vigil at the Opera House?
I don't know what you're suggesting.
Okay, thank you. Perhaps I can take you to a time when you were the Police Minister and when the Labor government in 2010 closed streets and provided a police safety escort for Oprah Winfrey for her Opera House show. Do you see any inconsistency in how your government failed to provide protection for the Jewish people in their own city but did provide an escort for Miss Winfrey?
I think it's a silly question, frankly.
It's an important question, Mr Attorney General. I'm sorry you regard that as a silly question.
You're really comparing the events of the last few weeks to giving Oprah Winfrey a police escort?
It's pretty
Where-
offensive, actually.
Okay.
Sorry, that's characterising the recent events in that manner suggests that you're not taking it seriously.
One of the pieces of legislation you introduced in the Parliament was the religious vilification laws,
Yes.
one of your election promises. The media reported that the crowd on the Opera House steps and on their way to those steps were chanting words which I am going to take on notice that we all know. I don't wish to repeat on this occasion. If those words were spoken, do you agree with me that that conduct would amount to religious vilification?
I don't want to preempt any work that the police might be doing. Can I just say, however, that the words that were spoken that night deserve comprehensive condemnation, and I abhor and condemn anti-Semitism and Islamophobia and vilification in all of its forms, which is why after Paul Lynch's religious vilification bill had twice been defeated by the coalition in the previous term of government, we moved within the first 100 days to enact protections for people on the basis of religious vilification.
And this was exactly the sort of situation that you would see that it would operate in?
Amongst many others, yes.
Thank you. And are you aware of Section 93Z of the Crimes Act?
I am.
This is, for your information, it creates the offence of
Don't
publicly...
worry, I've got it sitting in front of me.
Oh, good. Thank you. So you're aware of it. If the media reports are correct, do you agree with me that this conduct would amount to exactly the type of hate speech that is an offence under Section 93Z?
It certainly has the potential to do that, but I don't want to put any pressure on the police, who've already indicated that they are examining and I think have taken legal action against some of the proponents of those speeches already.
So you are aware of people being arrested while making those chants in the proximity of the police?
Just in relation to media reports that police have already...
So you have had no direct discussions with the police minister or the police, you're relying on media reports for your information about the enforcement of your new laws in 93Z of the Crimes Act?
I haven't been briefed by the police on what prosecutions they are intending to bring or have brought.
So you haven't been briefed?
By the police on prosecutions that
Yes.
they're bringing? No.
Okay.
Excuse me, Attorney, sorry. Would it be possible to just speak a bit more into the mic? I'm
Oh,
just
sorry,
struggling to hear you
I
a
thought
little
I
bit.
was.
Thank you.
Thank you.
Thank you. It's just the volume.
Yes.
Thank
Okay.
you.
If there's no clear public prosecutions, you would agree with me that there's not much point in having hate speech laws if people can chant racial epithets in front of the police and nobody is warned or nobody appears to be arrested for doing so. I would remind you that the only person arrested on the night of the 9th of October was a Jewish man who happily was waving a flag that didn't get burnt that night. I mean, rule of law requires public enforcement of the law so that community standards are clearly communicated. So would you agree with me that the law needs to be seen to be enforced for it to have any effect?
Yeah, as a matter of principle, yes.
So if a law is unenforced, what impact does this have on the rule of law?
Well, you're asking me to look into the minds of the police really effectively there and ask them why they aren't bringing these prosecutions, and I think it's premature of me to do that.
No, Attorney General, I'm asking you to behave as the first law officer, liaise with the police and ensure that the rule of law is upheld and that provisions like 93Z are seen to actually matter.
No, well, you're just presuming that there will be no prosecutions brought, and there have been a mere matter of weeks. The police have indicated that they're looking at footage. I do know that the police are looking at footage from that night from various sources, and they are investigating the conduct of people on the steps of the Opera House that night.
I make no
I have
presumptions.
been
I was hoping for
briefed
answers
about
today.
that.
You're the Minister responsible for the Summary Offences Act,
Yes.
and the way in which the Summary Offences Act works. A protest requires a permit in order for protesters to be permitted to march on public streets and interfere with traffic.
I'm not sure I'd characterise it exactly that way, but generally speaking, yes.
Okay, and the pro-Hamas protesters on the 9th of October didn't have a permit to conduct a protest march, did they?
Point of order. Just concerned about the characterisation of every single person who attended that event as pro-Hamas in circumstances where the resolution of the House prevents reflections on third parties, and in circumstances where I'm sure even my honourable colleague would admit that that is a quite extreme characterisation and probably almost certainly wrong.
I'm happy to
Do you wanna
reframe and
the
say...
question?
Yep. The protesters on the 9th of October didn't have a permit to conduct a protest march, did they?
No, I understand that they did not.
So when they proceeded to march from Town Hall to the Opera House, blocking roads, they did so illegally, didn't they?
I'm not sure they did block roads. I don't know. I wasn't there. So if they did, then potentially they did not have the limited immunity that's granted under Part 4 of the Summary Offences Act in relation to an authorised public gathering.
So if they did block roads as they were being escorted by the police from the Town Hall to the Opera House, and if they were in breach of the Summary Offences Act, and if all the police were doing was escorting them rather than stopping them, what is the point of the Summary Offences Act and having any lawful system of protest if it's not being enforced?
Well, Dave Hudson was sitting here a few days ago. You could have asked him that. And in fact, he was asked and he did answer it. And I can't add to it.
I'm asking you in
No?
terms of
Well,
rule
what's
of
the
law.
point? What you're doing and what the Coalition have been doing for the last few weeks is to continue upon an unprecedented, in my time anyway, in the 18 years I've been in this place, an unprecedented attack upon the police force. What you are sitting here doing now is second and third guessing for multiple times, not just you, but your leader and others, second guessing and calling into question the decisions made by police at the most senior level. And I'll tell you, Ms Carter, I've never seen such a sustained attack on the police by an opposition in the 18 years that I've been here, and as a former police minister and great admirer of the police, it's bordering on the offensive, frankly.
Well, quite frankly, Attorney, the attack is really directed at the executive, which was in fact absent and missing in relation to that whole process. So let me ask you in relation to that.
No, and I reject your characterisation, by the way.
Well, you have a characterisation, I have a different one. Attorney, you gave an interview to Ben Fordham on the morning of the 10th of October. Do you recall that?
Yes, I do.
Do you want to now apologise for your conduct in that interview?
In respect of which words, Mr Tudor?
In respect of the manner in which you told the Jewish community to stay at home? It's a fair question, Attorney. Do you want to apologise for the manner in which you conducted that interview?
So let me go to the transcript. What I said was, at the end of the interview, what I meant by that was that it doesn't...
Well, not what you meant, what you said.
I'm reading
What
the
you
words
said.
from the interview. And I will not
Point of order.
have you interrupt me either.
Point of
You
order.
will act
Please
courteously, as I have acted this morning
Well, you
as
didn't
well.
act
Mr.
courteously
Chair.
towards the Jewish community on that
And you can
morning.
ask another one.
Mr. Daley?
It's not a question. It's your statement,
Well, go on.
and I reject it.
Well, good. Do you want to now take this opportunity to apologise to the Jewish community for your suggestion that they should have stayed at home?
Okay, so what happened in the interview was that I assumed, as the questioner put to me, that there had been an order to stay at home. I had not been briefed on that. And so what I said in the interview, and I'll read what I said, was that I think if people want to gather quietly in communities and reflect and mourn and pray and do all of those things, that's one thing. But marching down the street and waving banners and
Yeah,
burning
I'm aware of what
flags,
the
that's
interview
another
was,
thing
but
entirely.
It was a
So-
disgraceful interview, Attorney.
Well, you haven't-
Go to the part where you
I
were
haven't-
suggesting.
I haven't finished my
Go to the
answer
part
yet.
where you were
Point of order.
suggesting.
I haven't finished my
Point of
answer
order.
Go
yet.
to the part where you were
I
suggesting.
haven't
there
finished
was-
my
Point
answer
of
yet.
order.
Point of order.
I would have thought when such, frankly, scurrilous and divisive things are put to the attorney, that my honourable colleague would allow him the dignity of responding. I think that is the least he could do in the circumstances.
I've already I've already ruled on that. Please allow the Attorney General to answer the question before you harass him again.
Thanks. And so when I gave that interview, I was not aware of any direction or lack of direction by the police to anyone to stay at home. The Premier gave an interview later on in the day when he said that it's possible that my comments gave rise to, I think the words he used, a sense of disproportionality. I accept that. And so, sure, I'm happy to offer an apology, Mr. Tudor-Hope, to anyone who was
Well,
offended
thank
by
you,
those
Attorney. We
comments on
could
the
have
day.
got to that position earlier.
Well, if you would have stopped
Thank you.
interrupting me, we certainly
Well,
would have.
we could have got to that position with a direct answer to my first question.
I'll
So,
answer,
let
I'll
me
answer
just
your
ask you this.
questions as I see fit, and I ask you not to interrupt me again,
Mr.
constantly.
Attorney,
So far, your interruptions have been a greater number than all the other people on this committee put
Good,
together
thank you,
in the
Attorney.
3 minutes that you've been speaking.
thank
And
you,
it's
Attorney.
very rude, Mr. Tudor-Hope.
thank you, Attorney. When you appeared on that program on that morning, you indicated you weren't across the material.
No, I wasn't across. I should have been clearer. What I wasn't across was I assumed that there'd been a direction by the police to the community to stay at home, and I should have been clearer about that. I should have asked the interviewer for more details.
Well, you told Mr. Fordham that you were working late and had not been briefed on the material. Is
No,
that
I hadn't
not
been
right?
briefed on a potential stay-at-home direction.
And you weren't really across it, were you?
I had no knowledge of a stay-at-home direction.
No, but you had no knowledge of what had occurred the previous evening.
No, I
Isn't
did
that
because it had been on the news, and I'd read the newspapers in the morning. Yes, I knew there was.
Well, that wasn't the impression, though.
No,
that you
well, I
gave Mr.
accept
Fordham.
that. No, I accept that.
And in fact, the impression you gave Mr. Fordham, in fact, was that you had not been briefed and weren't across the issue.
Yeah, I accept that.
And
Yes.
in fact, you said it was a matter for it wasn't in your portfolio.
Stay-at-home directions by the police aren't.
No,
That's right.
The issue relating to the demonstration which had occurred the previous night
Yeah,
wasn't
I
within
accept
your
that that could have.
portfolio.
I accept that could have given rise to a misunderstanding. Yes.
And when you go on a program like Mr. Fordham's program, do you get a briefing before you go about the issues of the day?
I was invited to talk about drug reform and the things that Ms. Carter had just been questioning me on, actually.
Indeed, but had you your media officer? Do you have a media officer in your working in your office?
Yes.
They had not briefed you in relation to that issue
They had.
before you went on that
I'd
program?
received all the media advice, and there was no mention in the advices that I saw of a stay-at-home direction that had been given by the police to the Jewish community.
No, but had you, in terms of the issues of the day, and assuming you're appearing on a program which is the most popular morning radio show, had you not been given a briefing in relation to the orders of the day?
Yes.
Or the issues of the day?
Yes.
Well, why is it that you told the interviewer that you weren't across this issue?
I was referring to the aspect of his question that went to a direction to the Jewish community to stay at home.
No,
I've got the
Attorney,
question.
If you have a transcript, that's misleading characterisation of the initial questions. If you've got a transcript of that interview that wasn't asked in relation to the stay-at-home order,
Really?
was it?
Oh, okay then. Okay, so Mr. Fordham says, so We had a protest last night outside the Opera House. The Israeli flag was burned and Jewish Sydney-siders were told to stay at home.
Correct. That's the total characterisation. And you said,
Right.
I haven't been briefed in relation to that.
No, I hadn't.
Yes, to the whole incident.
No. What I meant, Mr. Tudor,
Well-
and I've just said, I just conceded that my statement might have given rise to the apprehension that I didn't know that there was anything happening at the Opera House.
Well,
and I
that's-
accept that. My mistake.
Well,
I
that's
should have been
what
clearer.
I'm putting to.
And I've just told you that for the third time. It was the aspect of the Jewish Sydney-siders being told to stay at home that I was referring to when I said I hadn't been briefed, but I accept that I could have been clearer.
Well, in fact, you went on to characterise the reason is that you had been working late. Is that not the case?
Yes.
And do you want to tell us what you were working late on?
I was sitting in my ministerial office in 52 Martin Place with my Chief of Staff working on some cabinet submissions, finished work at about 9:30, went home, had dinner, watched the news and went to bed.
And you didn't see anything on the news that night?
Yeah, I did. I saw that there'd been protests at the Opera House, yes.
Well, you were in a position to be able to form a view in relation to that protest, having seen it on the news that night, were you not?
My recollection was that there'd been no mention of Jewish Sydney-siders having been told to stay at home on that news that night.
So, what time did you say you went home that night?
About 10 o'clock.
About 10 o'clock? And went straight to bed, did you?
Had dinner by
of
myself,
order.
went to bed, yeah.
Point of order.
Not sure where this goes. Not sure my eating
Point of
habits
order.
We've
have
had
anything to
some
do with the
extensive
Attorney
questioning
General's
that's
portfolio.
now leading to what time the attorney went to bed. It would suggest that
It is getting a bit
outside
silly.
of our task
Well-
in terms of scrutiny of the budget. And I would also say that this series of questioning has descended into badgering.
Well,
We've had repetitive questioning on this issue of what was said in the interview. It doesn't seem to be going anywhere.
Well, look, there's really no point of order.
Thank you. Attorney,
I don't think he's getting anywhere.
on his radio program, Mr. Ray Hadley suggested that you were affected by alcohol not only the night before but on the morning that you participated in that interview. This is your opportunity to respond to that allegation. What do you say to Mr. Hadley in respect of the allegation which he made in relation to A, your knowledge of the event, and B, the way you conducted yourself in that interview?
In respect of his claims about drinking, I reject them entirely. Not true. It's simply untrue.
Simply untrue?
Totally untrue.
So, as a member, as a member of this House, this Parliament, who has the fourth largest Jewish community in New South Wales in their electorate, do you say that that interview is something which you now regret?
Not the whole interview, Mr. Tudor, but as I've already answered to you, there were aspects of it where I could have been clearer, and I've apologised for my lack of clarity. Yeah. Sure.
Thank you, Attorney. I think it is probably one of the more regrettable parts of your performance as Attorney, and you have had the opportunity of apologising, which you have done.
I know you're frustrated being out of government, and it's showing.
No? I just know that I would have done things differently, Attorney.
Mr.
And
Chair,
maybe I would have known what I was doing before I appeared on a radio.
I know, and if you and your colleagues were such
Point of order,
geniuses,
point
you'd
of
be
order.
sitting there and not there.
Let's keep things civil, please.
if I could take you to another topic, Mr. Attorney
Please
General.
do, because that was...
The Sheriff and Court Security Amendment Bill 2023, which is currently before the House.
Yeah.
Has the proposed rank structure for sheriff's officers been costed?
Unless somebody can answer that, I'm happy to take that on notice. Yeah, I'll take that on notice.
And thank you. And while you're taking that on notice, perhaps you can tell us how much it will cost,
Yes, happy to do that.
and if the bill is enacted, how this cost will be met. Will it come from DCJ's budget? Will it create a shortfall? Will a PTA be submitted to meet the shortfall? And if not, from where will the funding be taken?
Certainly.
Yeah, you've got all that on notice?
Yes,
Great.
thank you.
Thank you very much. Thank you. I don't think it's worth asking another question with 20 seconds to go. So.
Thank you. Attorney, you said in answer to some questions just then about the protest at the Opera House, and that you are being briefed, or that you have been briefed about the investigation into allegations of hate speech? I think you said you might have answered that.
I said that I had been briefed that police were having regard to video footage.
Have you, in that, in those briefings that you've received, have you been made aware of any allegation around the truth of that video footage or the reliability of the video footage?
Reliability in what sense?
That that what it appears to be on the video footage is a reflection of what actually was chanted?
No.
Nothing at that degree?
No, it didn't go to that level. I just understood that police were having regard to video footage taken from sources, areas around the Opera House.
And when
I will have to be careful about what I say. For
absolutely,
security
I understand that. Thank you. When were you briefed about that?
I'm not sure I'm at liberty to disclose particular details, but it was within 48 hours.
And are you receiving ongoing briefs?
No.
So nothing since that 48 hours ago that you've had any discussions with
Casual
anyone?
conversations, but no, with the Minister for Police and her staff, but no official briefings from the police, no.
And so in those less official conversations with the Minister for Police, what's your understanding of where things are up to at the moment in terms of investigations of that night?
I haven't been briefed on those on that detail, that level. I wouldn't expect to.
Why wouldn't you expect to?
Because the police don't, as a matter of course, brief the Attorney General on prosecutions that they are looking at initiating.
I understand perhaps in general, but do you see this as something that is not of general sort of criminal nature? Do you understand that this is something that is incredibly novel, what's happening in New South Wales at the moment?
Yeah, it is. It's novel and it's concerning. I hope it's over sooner rather than later, and it will be my intention to get an update from the Police Minister in the next week or so. But up to this time, one hasn't been offered, no.
And can I'm just going to say at the outset, I'm going to say words I would never naturally say, and they're words that are not repeated here for any reason other than to gauge a view. I'm sorry, I'm just preempting what I'm saying.
I understand, yeah.
Thank you. Attorney, is your understanding of words gas the Jews, is your understanding of those words from a criminal perspective different to the words fuck the Jews or F the Jews? Do you understand the difference in those in terms of the criminal law?
I'm not really sure what you're asking me here, Ms. Higginson.
Okay, so the former words, if they are chanted...
Well, they're all inordinately offensive.
Without a doubt. Unacceptably. Disgracefully. But do you understand from a criminal law perspective, would you see there is a difference in the former words, if they were chanted, to the latter two sets of chants?
I suppose what you're really asking me is to have regard to the words and then apply them to the words that are set out in 93Z or in the Anti-Discrimination Act, and I'm not sure I can advise you in that regard today, Ms. Higginson. I'm not sure where you're going with this line of questioning. I'm not sure what you're really after. I'm trying to help. I just don't know that I can.
Thank you. I'm asking if you are being updated, if you've had a brief in relation to investigations. I would have thought.
No, I haven't.
And correct
but
me.
I haven't.
I thought you said you had been briefed.
No, I had a briefing in the first 48 hours about the measures that police were adopting to have regard to the activities at the Opera House, and nothing about the investigations after that.
All right. can I just go back to raising the age? We'll move on. Thank you.
Sure.
With the 4 children who are currently incarcerated in New South Wales, are you aware that 3 of those young people are Aboriginal children?
No, I'm not specifically aware, but it doesn't surprise me,
Okay.
unfortunately.
So your diary disclosures, Attorney, don't, and I would love to be wrong, but I can't see anything that suggests that you have met with any of the Raise the Age campaigners or the organisations involved in raising the age, and that I can see only one meeting there with the Aboriginal Legal Service. Would that be correct?
I haven't got my diary in front of me. I'm meeting a Raise the Age group next week. I met with PIAC and discussed Raise the Age with them early on in my tenure as Attorney General.
And did that, in those, without disclosing it, did you come away from those meetings with a view that a full understanding of the evidence that is piled very high over months and months, years and years, of the impact of raising the age and the negative, the expert advice that raising the age of criminal responsibility is something in the public interest?
I accept that evidence.
So why are you not? What is it that your only reason? So are you supportive of raising the age of criminal responsibility?
As a general principle, I accept that there are better ways in relation to some young offenders, not all, than to divert them away from the criminal justice system and deal with them in different ways rather than simply locking them up. I accept that. But it's the alternative pathways that are the problem. As First Law Officer, and I join with the Premier and the Minister for Police in saying that our first responsibility is to uphold community safety. That's our paramount consideration. But if you're going to go to an alternative model, you've got to make sure that there are comprehensive supports available in every corner of the state, not just in the city, but everywhere. And we are a long way from that.
So, Attorney, what are you aware then of what the sort of offences these young people are experiencing rates of incarceration due to? Like, are you aware?
So I just didn't hear you first.
Are you aware of the kind of offences and the criminality of the young people that we're incarcerating?
The offences they've committed. No, I've not received a brief, a breakdown, but I can, from my experience as Minister for Police and other, I imagine and have some knowledge of the things that they would be incarcerated with, yes. A range of offences. Some of them are quite violent. Very violent offences.
And some of them are not so violent,
That's
Attorney.
right.
And some of them are, the reason young people, I'm sure you know this, but the reason young people end up incarcerated is because of significant complex traumas.
Oh, yes, I accept
and because
that. Yep.
of significant disadvantage. Attorney?
Yeah, and we do have the Young Offenders Act.
3
Ms.
of the
Higginson.
4
The
children
Young Offenders
incarcerated
Act,
are Aboriginal children.
yeah, I accept
Point
that.
of order.
I accept that.
Point of order.
Point of
The point
order.
of order is the same one I made earlier. The attorney's entitled to answer the question, not be talked over.
We were having a very, to the point of order, the attorney and I think
yeah.
were having a very civil conversation, and I don't think there was any.
I know-
And can I remind my honourable colleague, the Attorney General is very fit to defend himself here in the questioning.
It's not about defending, it's about
Order.
courtesy.
Order. I think the Attorney General is quite happy with the line of questioning, and he's dealing with it properly. And I noticed he nodded a few minutes ago. He's quite happy to continue.
So where were we?
I think we were. I was pressing the point that the three of the 4 young people are Aboriginal.
So the Young
children.
Offenders Act has significant provisions in it, as you know, to divert children away from prison. And so we end up with a small number of children that are incarcerated. Look, I speak to the police about this often. I have regular meetings with Nell Skinner, the President of the Children's Court, about this. And it does weigh heavily on my mind, but we've got to have, Miss Higginson, alternative pathways for them. And that's what I want us to start looking at in earnest, and we will, and we are doing that in conjunction with what work done at a federal level. Don't get me wrong here. It would be something that would bring great benefit if we could get it done. We need to bring the police on board with it if we're going to do it at all. But it'll be long and slow work, and it will require significant investment, and we're nowhere near it yet, to be honest with you. Nowhere near it yet. Sure, Mr. Tidball might just give you some details on...
If I may, Ms. Higginson, assist the committee just by indicating the current numbers in youth detention. So there are currently 0 under 12 years in custody. There are currently 6 children under 14 years in custody. Those 6, each of those 6 is on remand, and 0 are on control.
I don't think they're the figures that were quite given to us in budgets a couple of days ago, but fair enough, maybe something...
I'm happy to...
I've literally got
hearing,
written here from for answers that were provided in budgets less than a week ago, and it was that there are currently 4 children under 14 years of age in custody, and 3 of those are Aboriginal children.
My date, my extraction date is the 29th of October, but I will clarify.
All right, well, maybe there's some discussion there about what's happening, but I think the premise really is that anybody under the age of 14 incarceration is really not where we should be, and I think the attorney knows that. When you say, though, I
understand that, Ms. Higginson, but you also have to keep in mind that some of these young children are bring significant risk of danger to themselves and others, and so we have to make sure there's a regime that keeps them safe, keeps the community safe, and seeks to divert them in a proper way, and we're not there.
Have you been to a detention centre, attorney?
Not a children's detention centre, no.
Okay.
But I have sat with the police after I'd been the Attorney General, and I have watched videos of some of the conduct that these young children are being involved in, and it's pretty horrific. So community safety is our paramount concern. Let me make no mistake about that.
I just want to go to the outcome that you and I are both very familiar with in Kathleen Folbig's matter, and obviously now the Bathurst full report has been tabled. Is it your view that here in New South Wales we should be concerned with both sides of justice, not just convicting people but also freeing innocent people?
Of course.
Is that an of course?
Yes, of course, yes.
All right. And so do you think it's important that our legal processes are the best that we can be providing in terms of both sides of justice?
No doubt. I accept that, yes.
Okay. And so, Attorney General, you're the only person right now, in real terms, who can provide a pardon to somebody, and you're actually responsible for determining if any case gets reviewed once somebody has been convicted. That's right?
I certainly am.
No, that's
no. I know I do have the capability to do that, but...
The Supreme Court can order a review in criminal cases of its own motion.
I was sorry.
That's still Cara?
My question
That's
was
Cara.
to pardoning. Sorry.
Pardoning. Well,
Yeah.
I recommend it to the governor, yes.
Yeah. But ultimately, it's I mean, the governor will act.
That's
Yeah.
on
So in
advice,
terms of
yes.
a pardon,
Yeah.
you're it.
Yeah.
Do you think
not
that's
just me? There has to be a significant process under the Crimes, Appeals and Review Act before that. I can't just wake up. Well, I wouldn't wake up and pardon someone. It's not contemplated under the Act. No.
And do you think it's time that we have a better system than just you?
Then this. So what are you? What are you getting at?
Well, I mean, I think I wrote to you and asked you about whether you thought whether you were open to us having a review of the way we do post criminal conviction reviews, and whether a criminal case review commission would be something that you would be open to. Are you open to that idea of looking at what we could do and do better?
Yes, so I was asked that question in the press conference where I announced the pardon, and I said that it would be something that I'd be open to looking at, as I am in respect of all legislation.
And are you open to that?
Views. So, well, I said it then, and I am now, but I noticed that I do note that would be a standing commission of inquiry where none exist in Australia now. There are only a few that exist overseas. But the short answer to your question is yes, I'm open to it. But it's not a priority for me at this time, I have to say. But I'm open to receiving submissions about it, and if I receive them, I'll refer them to the department and we'll look into it. But I do acknowledge that there are some imperfections in the CARA scheme.
And so, does it not concern you then that what's just been dropped on your table is a comprehensive report of comprehensive failure, and that one woman, amongst, I'm sure, others and men, have been wrongly convicted and held in prison for, in Kathleen's case, 20 years, and that every attempt that she made to access a post-conviction review process also failed her, and then only just we've seen that how bad and how systemic that failure has been, and that's not a priority for you to look at how we could do better.
That is one characterisation of what's occurred. There are others.
Oh, what else do you think we did to Ms. Folbig?
No, I'm saying there are other characterisations of other parties that might differ from yours. I'm sure there are a range of views. However,
hang on, Attorney. Can I just ask you there?
No. This matter is
can I
this matter is before the Court of Criminal Appeal, or will be shortly, and I don't really wish to go into this at all.
Well, that's not your... sorry, I'm a bit confused. Are you suggesting now that what's just happened does not show that there's been systemic failure?
No, I'm not suggesting that. I'm saying that you put to me a number of assertions with a conclusion at the end, and I accept that that's one characterisation, and there will
So
also
can I
be
ask you,
others.
Attorney, what is another characterisation of what the state has done to Kathleen Folbig?
Well, I'm not going to go into hypotheticals.
I'm not asking for a hypothetical.
Well,
I'm asking for...
because you're asking me
No,
to canvass.
you said...
You're asking me to canvass possible views that other people might have.
No, you're the one that put to me there are other views. What are those views, Attorney?
There would be other views, yes.
I have not heard any other views. I've not heard one other view.
That might differ with the characterisations as you put them to me.
Have you read the full report that was tabled by Tom Bathurst?
This week,
Yes.
I started at 660 pages long, and
Yes.
it's got dense medical evidence. And
Yeah. Have you read the top lines of where she's been failed throughout the
yes,
entire
and it
system?
accords with the preliminary advice that Mr. Bathurst provided me in June. Yes.
What's your view in relation to wrongful convictions? What do you see? How grave do you see it is when an innocent person is incarcerated?
Hugely grave.
And as the Attorney-General of New South Wales, surely you would want to change the fact that we can now see how wrong the system can be.
And that's why we'll wait for what the Court of Criminal Appeal has to say, and we'll look at any shortcomings that they might bring
I
to our
don't think,
attention.
with respect, Attorney, there is Kathleen Folbig's path of justice, and that's happening in the face of the gravest
Time.
injustice.
Time.
No,
We've given
I'm
our
sorry.
time. Should go
And
first.
there's also the grave system failure that has taken place, including the post-conviction review process failing her several times. Why is it not a priority of yours to fix the post-conviction review process of New South Wales?
With regard, fix it in what regard?
Improve it.
How?
Perhaps a post-conviction review commission of some sort.
Just told you that I'm open to that.
And I'm asking, and you said it's not a priority. I'm asking you to explain, in light of the circumstances of which we've been presented through the Bathurst report, and there's others, but why that's now not a priority for you.
When I say it's not a priority, it's not one of the initial things I'm working on at this time. But I am open to it, and we will have a look at it in due course.
Thank you. So if you're presented with material around what that reform would look like, you're very open to moving on that, and perhaps in a more swift manner than a non-swift manner.
I don't want to give any indication of swiftness, but I've already indicated that's something that I'm open to looking at. Yes.
And you accept that that a system that can fail so badly and hold somebody in prison in circumstances where they shouldn't be there, that is a fundamental consideration for you as an Attorney General.
That would be one of the fundamental considerations if we were to look at going down that path, yes.
Thank you.
Thank you, Attorney General. Do you remember the alleged murder of Liesl Smith on the Central Coast in 2012?
I don't remember it, no, but I'm aware of.
You're aware of the
in general
case?
terms, yes.
It was her ex-boyfriend was arrested and faced a judge-alone trial, but took his own life a day before the verdict was due to be made public in July 2022. Justice Elizabeth Fullerton said the law prevented her from saying whether she had decided to find the defendant guilty or not. He pleaded not guilty. It has been reported that Liesl's sister has been in contact with your office in the hope of getting the law changed, but has not received a response. Has your office responded to Liesl's sister?
I'm not sure where that response is up to, but I'm certainly aware that correspondence came in, and I've referred it to the department, and they're looking at it, and I think that we're probably close to getting a response out, I think. But we will take that on notice and see where it is, yeah.
Attorney, could you attempt to get a response to that, of when you will respond to her, but by the end of the session?
Yeah, sure.
Thank you.
I just have one more question in relation to the raise the age issue. I just wonder, Attorney General, if you could give us your view of the current functioning of the Daley and Capax doctrine and whether this actually allows for a child-by-child consideration.
A child-by-child consideration of what?
Of their criminal responsibility.
Yes, it does. Case by case.
And so you're happy that this child-specific test of criminal responsibility exists and that it's functioning well at the moment?
Yeah, I'm not sure it's functioning well. But that's what the law is at the moment, and
you're satisfied with that law at the moment? And you see no reason to change?
That's something that I'll look into, but it's not a perfect system because it relies on the prosecution having to go and get psychological and other evidence as to what the capabilities and mental capabilities and capacities of the child are. And sometimes that's difficult, but that's in a difficult system. That's what we have at the moment.
Yeah, so difficult.
It's not perfect, but that's what we have. When faced with imperfection, one should always try and see if there are better ways to improve it.
Okay, thank you very much, Attorney.
All right, we might take a break there. I suppose there are no government questions. All right, and we'll return in 30 minutes.
Oh, really?
Don't get excited.
He already is.
I'm excited. It's the last budget estimates day.
Start again. Questions from the opposition?
Thank you, Chair. Attorney General, would you be aware of the...
Sorry, Ms McLaren-Jones. Mr Chair, we took some questions on notice before. Would you like us to read some of the answers that we have into the record now, or
Are you happy to do that? You happy to do that?
As long as
now?
they don't take too long.
as long as the clock doesn't start.
It won't. Yeah, please do. Yep.
Okay.
I can be quick in relation to the, so just clarifying, Ms Higginson, the youth detention
Yep.
question. You're right in your recall. We've checked that. Those figures which were given in evidence by Candice Nielsen from YJ were on the day and they were correct. Mine, quoted on the 30th of October, were also correct. The key thing about youth justice numbers at the moment are it's been heavily driven by remand, and a number of those remands, as you probably know, are very, very short. And in terms of the figures today, there are 9 children under 14 years old, and all are on remand. There's one child 11 years, there's one child 12 years, and 7 children 13 years of age.
Do you have, by any chance, the proportion of Aboriginal or First Nations children?
4 of the above, yes, I do. 4 of those 9 are identify as Aboriginal.
All 9 identified.
No, I said 4 of the 9.
4, sorry, thank
4.
you.
That's all right.
Thank you, sorry.
And so that's that one. And just in respect of the sheriff issue raised by Ms Carter, Ms Carter, in respect of the miscellaneous sheriff
Thank you, yes.
amendment, just so what that piece of legislation does is effectively formalise a rank structure that's been in practice in place for some time. So has it been costed? Yes, but the cost is 0 because it's just formalising that structure, as I say, which has been in place.
Thank you very much.
Thank you.
Thank you very much.
Sorry, just one more. I was asked a question in relation to whether we had responded to correspondence in respect of Liesl Smith. I'm advised that a response will be provided within a week or 2.
Sorry, I found that very hard to hear. Could you talk a little
Yeah, I don't know what's wrong with my microphone. With respect to correspondence from Liesl Smith in response to the Liesl Smith matter, a response will be provided within a week or 2.
Thank you.
So it must be back from the department.
Thank you very much. Attorney General, you'd be aware of the Magistrate's Early Referral into Treatment, also known as Merit Program.
Yes.
And that this program has been measured to reduce reoffending by around 12%. What is the expected success rate of your new diversion program?
I think I'll ask Anne Campbell from the department to answer that, please.
I need to take that on notice, but certainly happy to provide it this afternoon.
That'd be great. Thank you very much.
Could you just clarify what the question actually meant?
The question is of the new program that you've announced.
So this is the new diversion for drugs?
Yes.
Yeah.
If you have, how much you expect it will reduce the rates by?
Reduce people going into the merit program, do you mean?
No. Well, compared to the
They're
reoffending.
different programs, though.
Yes, yeah. So I was just using the example that the merit program, when it was evaluated, found the rate was around 12%. I'm interested to know what you expect the rate to be of your new program.
Understand. Okay, yeah, thank you.
Could you also advise if you've set a date of when you will review your program?
Yeah, okay. I'm not sure.
If you're talking about the merit program,
No,
the
new program, the new diversion
new
program.
Fines Act drug diversion,
No.
court diversion
I
program.
need to take that on notice.
Are you intending to review it?
I'd have to go back and have a look at what the embedded mechanism for review is. I don't know off the top of my head.
Okay.
But it should be reviewed.
Yep.
In fact, I'll be very interested to see what the results of it are, actually. So, yes, there'll be a review.
In relation to the merit program, is much more extensive than the health intervention proposed under your current policy. Why did you decide to introduce a new policy rather than resource or further expand the merit program?
on the basis of advice from the Department of Health and the Chief Health Officer. They're two distinct programs. One is run in the local court at a certain point in proceedings, and the other one is pre-proceedings. It's designed to keep people out of the court.
And what exactly was the advice that you received from Health?
In respect of what?
You said that they advised you that the merit program, or did they advise you that it wasn't successful, or that you shouldn't expand it?
I don't understand the question. Did they advise me about? Did they?
You just said that
the merit program?
You decided on your policy rather than the merit program based on advice from Health.
No, the program, the pre-court diversionary program, was all put together on advice from Health, but it's totally distinct from the merit program.
And what was the Department of Health, I'm just wondering, just getting some clarity, Department of Health advised you that you should implement this policy?
So in relation to the merit program, it's available in 62 local courts. It's been expanded and it will result in the service being available at 30 additional local courts. So it'll be 92 local courts the merit program will be available to after it's fully expanded.
Yes, but the policy that you have, your diversion policy, you said that it was based on advice by Health.
Yeah, Health put the whole package together. We've been through this already this morning.
Okay.
Why did you follow that advice? Why were you persuaded by Health? Why did you decide to introduce that rather than further resource merit?
Because they're totally different concepts. One is a pre-court diversionary scheme for low-level drug offending where we try to keep people out of the courts. I don't want them appearing in court. If we can get people who've been apprehended carrying drugs into treatment early and not have to put them through the justice system, that is a much better outcome than having them charged, put before the court, and then
I
into the merit
understand that
program.
they are different. The question is...
But it's up to the police officer. If the officer thinks that merit program might be a better assistance to them, then they'll use their discretion to put them through the court and not have them issued with a sin.
The question is, what persuaded you to follow the Health advice and introduce a diversion program as part of the criminal justice system?
Because there's no reason I had no reason to question it, that's why. And it makes perfect sense.
So any advice you get from Health, you just accept?
And this work had been done largely before we got into government. My decision, the decision which was left to the new government was whether we forsook all of the work that the police and the health department had done over many, many months and wait until the drug summit to see what we would do, or whether to put that good work into action now. We decided that the best course of action was to put the program that they had come up with into fruition now.
And the question for the incoming government was whether it would be resourced equally throughout the whole of New South Wales.
Well, do you want me to take that on notice? I think we've gone there as well. I think it is, but if you want me to go and check what that is, I can do it, but I'll have to get the advice from
I would be delighted
Health.
to receive details of how it's to be implemented across the entire
Well,
of New
that will
South
be
Wales.
advice that we'll have to get from Health, so it won't be forthcoming today.
No, thank you.
Attorney General, just following on that, in relation to the advice that you did get from Health, I'm interested to know about particularly the rehabilitation beds and what will be made available. Were you given advice and details about how many rehabilitation beds would be available and the cost?
This is a telephone counselling and telehealth counselling program, and there will be no drug and alcohol rehab beds attached to it, unless I'm mistaken.
Can I take you to the information we received from Kerry Chant in estimates, where she said it could go from a telehealth up to a drug and rehabilitation?
Okay, sure. Well, if that's the advice that you've been given by the person who's running the program, then I have no reason to question it.
So if it's your program, have you costed rehab beds as part of the program, since you say it doesn't include rehab beds?
I'll get some advice on that. We'll take that on notice.
Yeah.
Attorney General, I come from a health background, a nursing background, so I don't have a legal background, but I am interested particularly as the first law officer, and you indicated before that your role was to facilitate a framework for this. Did you ask the questions about how Health intends to roll this out equally, whether it's metropolitan or regional areas, to ensure that some of our most vulnerable people are supported?
No, because the regime that was left to us was where there was advice that was sought from the Commissioner of Police and from the Chief Health Officer as to the state of readiness of those two departments as to in respect of if such a scheme was going to be introduced, and the advice came back that they would be operationally ready within 6 months, and they gave it an approval based on operational readiness within 6 months. That was the framework that was left to me from the previous Attorney General and previous Minister for Health and previous Minister for Police.
But you didn't ask the questions.
Ask what questions?
Did you ask them to clarify when they would be up and running, and whether or not they had the resources and the support to actually implement this?
The written advice that was sought was as to how long it would take for them to be operationally ready to implement the scheme. Their written advice came back that they would be operationally ready within 6 months.
And do you have a start date of when this will come into effect? Because before you said it'll be sometime next year.
In 6 months is sometime next year.
But you don't know when?
I can get a precise date for you if it's possible to ascertain one. But it will be really up to the Department of Health to say we're ready to go. But the advice in writing from the Chief Health Officer was that they would be operationally ready within 6 months.
Could you tell us what your instructions were to the departments as to what operational readiness meant?
No, because that was an instruction that was given by the previous government, and we received the advice. The advice was sought by the previous government, and it was delivered in this term of government.
So you're simply saying that you are a conduit through which this program passes, and you have no oversight over it?
Not over the delivery of the health aspect of it, no.
As First Law Officer, you do not have oversight over how this intervention, which takes the place of a criminal infringement notice, operates?
I don't know, Ms McLaren-Jones, have you ever had an Attorney General ring you up and tell you how to administer matters within your nursing capabilities? No.
Well,
So the answer is no.
I'm sorry, we're
No.
you're not here to ask about when I worked as a nurse 20 years ago. We're here to ask you questions as the Attorney General who put forward the legislation, whether or not you're actually across the detail of what you were recommending.
Sure.
That's your answer, sure.
No, you just made a statement. There was no question in that.
I heard my colleague ask the question, are you across the detail of the program that you are responsible for implementing?
Insofar as the responsibilities and legislative aspects of it fall to me, yes.
And your responsibilities stop at ensuring equal implementation for every citizen in New South Wales, do they?
No, my responsibilities don't include the administration of drug and alcohol rehab services that fall within the purview of the Minister for Health.
Do your responsibilities include making sure that there are equal interventions available in the AOD space for every person who is given a CIN?
In what respect?
In the respect that this program is a justice program, and if somebody is given a CIN and the opportunity under your amendments to fulfil that as a diversion program, that every single citizen has the opportunity for the same diversion program regardless of their postcode.
I think we've been over this already 3 or 4 times, Ms Higginson.
But it'd be nice to get an answer.
I think I've answered it already
very well.
many
Multiple
times.
times.
I have
25 of
Well then perhaps can I ask you, if an offender in a regional area receives a tailored health intervention which requires treatment in rehab, and then there is no rehab bed available for them, what happens?
Well, happy to take that on notice. I'll ask the Minister for Health to provide me with some advice.
So the
and
Minister
I
for
do
Health
know,
will tell you the consequences for somebody who has a CIN. Because the
no,
question I have for you, Minister,
that wasn't
is...
the question.
That is the question.
The-
If an offender in a regional area receives a tailored health intervention of the kind foreshadowed as part of your plan, and that tailored health intervention requires rehab treatment, and there is no rehab bed available for them, what happens? do they have to pay the fine because the government has not invested in the health services in regional New South Wales?
That question goes to the provision of health services, and I'm not able to answer that.
With respect, Attorney General, it goes to, I am an offender. I have been given a CIN.
No, the responsibility is on the Ministry of Health to provide the treatment that the scheme makes available. That's their responsibility.
So what we're to take from that is that the first law officer is telling us that under the drug diversion program, there is no responsibility to make sure that there are equal outcomes for people with criminal and infringement notices. That's a matter for health. And that somehow delivery of offender prevention programs has become a health matter, not a justice matter?
I don't know if you're deliberately conflating two issues, but you are.
Let's go back to the role play.
Nah.
I am a drug offender in Dubbo. And I have a criminal and infringement notice, and I ring up for my telehealth, and my telehealth tells me that what I really need is a rehab bed in the way that was foreshadowed by Dr. Chant. I can't get a rehab bed for 4 months, not unusual in regional New South Wales. Because I can't get the rehab bed because it hasn't been resourced, do I have to pay the fine?
I'm confident that won't happen. You're asking me a hypothetical, and you can turn this inside out as many ways as you want. I can't answer it differently.
I'm not trying to turn it inside out. I'm trying to establish whether the people of regional New South Wales will have the same access to justice as the people in the cities.
I'm sure
which
they
is a fundamental question which goes to administration of law in this state.
I've got confidence in the Department of Health, and I'm sure they will.
So, could you just say that again? What I heard you say was that you have confidence in the Department of Health delivering equal justice outcomes for the whole of New South Wales?
No, equal health outcomes across New South Wales.
But this is a justice outcome.
No, the consequence of it is, but the delivery of health services is not mine.
With respect, I think
No,
the person
sorry,
responsible for the conflation
Mr. Chairman,
is you.
I can't answer this question differently.
I can see you can't answer the question.
10
That's
times
very
I've been
clear to
asked
me.
it, so let's move on.
Thank you, Attorney General. How many magistrates are authorised under the DSPO scheme?
I'm not sure. Take that on notice.
I don't know.
Can I also then ask what you're doing to promote the scheme amongst the magistrate?
Look, I'll have to take some advice on that.
Could you then answer potentially, well, how many DSPOs have been approved to date?
I'll take that on notice.
And how many have not been approved?
Sure, we'll get that.
Thank you. Perhaps we can go to Western and regional New South Wales. Have you had any discussions with the Police Minister about crime rates and rising crime rates in these areas?
Briefly.
Okay. Are you considering any law reform as a result of your brief discussions to support police operations and public safety in these areas?
Not at this stage.
Not at this stage. Are you considering implementing or funding any crime prevention initiatives in affected communities?
That's not a matter for the Attorney General, it's a matter for the police.
Okay. So if you're not considering any law reform at this stage, what would have to occur for you to consider law reform initiatives to protect the public safety?
Well, I have confidence that the police will do their job and will continue to do their job. One of the things that they're hampered with, of course, is that they're short of officers, and that's one of the concerning things that this government has inherited from the past.
Minister, perhaps you could update us in relation to OPCAT and where the negotiations are with respect to Commonwealth and funding.
OPCAT is being discussed at a federal level through the Coalition of Attorneys General, and at the next meeting, correct me if I'm wrong, Mr. McKnight, there'll be a 1st of December?
It's not on the agenda.
It's not on the agenda, so it's been progressed at SCAG, but it's not on the agenda for the December meeting.
Okay, and has the Commonwealth committed to fully fund New South Wales costs to implement the protocol?
Not at this time.
Do you anticipate that they will?
I don't know. You have to ask Mark Dreyfus and the Federal Treasurer about that.
I wonder, Attorney, whether it's a question you should be asking Mark Dreyfus rather than us.
Well, Mark Speakman had no success in convincing him, so we'll keep
So,
progressing.
what are you doing to advance these negotiations?
Getting involved in them at SCAG with my other state colleagues to try and land a good outcome.
And if it's not on the next SCAG agenda, do you have any understanding of when it will be considered by SCAG?
I could take that on notice.
Thank you. That'd be good.
There's a working group set up to consider, isn't there? at the federal level?
There are officer discussions which are happening to really specify the requirements that would arise and the specifics around the manner in which the national preventative mechanism would operate.
Right. And are you seeking to put it on the agenda of SCAG?
Am I seeking to? No, it's got a life of its own. It'll be put back on the agenda at the appropriate time.
So we're not playing any active role in this, we're just waiting for it all to happen?
No, well, if I can just amplify my earlier response to Ms Carter, we are actively working with the national preventative mechanism, although it's national, will be stood up effectively on a federated basis. So we are working with the Commonwealth to seek to determine what the requirements would be at the point of implementation, because from that you can actually work out what the cost will actually be and the impact on resources.
And is there any understanding of who's going to meet those costs for New South Wales?
The position of New South Wales remains that the Commonwealth should pay.
Does the Commonwealth share New South Wales' position?
That's what negotiations are all about.
Right, thank you. And if and when negotiations are sufficiently advanced, do you anticipate any law reform to support implementation of OPCAT?
Any law reform?
To support implementation?
I'm not sure that there'd have to be law reform. There might have to be some access reform within departments, but law reform, I'd have to take that on notice.
Okay, if you could take it on notice.
I'm not
so
sure.
To my knowledge.
No, I don't.
Yeah.
I don't think so.
So you think it would be purely administrative?
I think it's just funding and access.
Funding, access,
And the
administrative.
operational requirements.
Yeah.
Okay.
So
Great,
we have
thank
very
you.
clear operational requirements about when an oversight body visits any facility. Clearly, those arrangements would be important for the operation of OPCAT. Similarly,
And it would cover all facilities, you wouldn't be seeking to exclude
correct.
any?
Police cells. It's not just prisons. The 36 prisons in the state. It would be police cells, youth justice centres, and forensic health facilities.
Including forensic health facilities?
Yes.
Okay, thank you.
Attorney
Sorry,
General, how many
I'll just get Mr.
Attorney
McKnight.
General
There is-
meetings have been held?
Sorry.
Sorry, there is one piece of law reform that will be necessary.
Sorry, it's very hard to hear.
Excuse me. There's one piece of law reform that will be necessary should there be a national preventative mechanism established in New South Wales, and that is to allow for inspections of police cells. There is an inspection regime in place at the moment that covers prisons and youth detention centres, and a regime that covers psychiatric hospitals where people are detained, but there's not a regime that covers police cells.
Thank you.
Thank you, Chair. Good morning, Attorney General.
Good morning, Ms.
How are
Mahaley.
you? Good. You enjoying being the first law officer of the state?
It's a great privilege. Yes, I am.
Not a little bit daunting?
Not at all.
No, that's good. Can I just ask you a couple of questions? One, I wanted to just ask you in relation to how the anti-discrimination, your modernisation of the anti-discrimination law plan is going, because you've taken on a very ambitious task of deciding to, in your words, modernise the Anti-Discrimination Act. It hasn't had a review since 1999. Could you give me a little bit of how you're going with that?
Yes, so the first thing we did, as you know, is to add religion as a protected attribute for the purposes of vilification only in the Anti-Discrimination Act. We did that within 100 days, as we promised we would, and then we referred the entire Act to the New South Wales Law Reform Commission to...
When would that be finalised?
Sorry, point of order, I apologise. Would it be possible for the Minister to draw his microphone a bit closer? I'm really struggling to hear.
I don't know why. Is it
Yeah,
on?
you're...
It's on, yeah.
no, it's on.
I can hear you perfectly.
That's better.
Right.
I know you very well, Attorney General, so I can hear you very well. Can I just, you have, that's right, it's currently before the Law Reform Commission. Submissions, have people been invited to make submissions to that process?
Yeah, that's chaired by Tom Bathurst. We've also given him the assistance within DCJ of an eminent person whose name escapes me. Phil knows to assist. Kate Eastman. Kate Eastman's helping him do that.
There's no draft yet available. It's still
No,
it's
it's early days.
Early days.
They
Okay, so
ru-
it
that-
is early days. You're not expecting anything to come back, obviously, this year. So
No, it won't be this year. I don't want to put any pressure on Mr. Bathurst and his team, but it would be really lovely if we could get something by late next year.
Oh, late next year. Okay.
Yeah.
So it's plenty of time.
It's a huge body of work, as you know.
Yes, no, it would be, and it would be, I think, very contentious, and a lot of people have a view about
Yep.
it. Can I also ask you how are you going with the conversion practices legislation? As you know, the Premier committed to banning gay conversion practices, and we all agree they're very abhorrent, and so they should be banned
Yeah.
prior to the election. In the meantime, the member for Sydney introduced his own legislation, which isn't just about gay conversion practices, but now just refers to conversion practices prohibition. Where is the government up to in relation to
That work is well underway, and without giving you a timetable on which to hang me, we hope to have something to the Parliament as shortly as we can get it there.
Well, there must be a draft bill already. Is that right?
Well, you're asking me to talk
Well,
about.
you've just said Parliament's on in a week's time.
I'm hoping we will have something very shortly.
At this stage, you don't have anything.
I don't want to give you a definite timetable.
Well, you've just said to me you're going to have something shortly to Parliament, so it will come in the November session. Is that what you're saying?
No, I've just told you I
Do you
don't.
know what the name of the bill will be?
Please don't interrupt me. No, I do.
You're not going to provide
no,
that? Will you
no.
provide the committee with the name of the bill?
You'll see it when it's introduced to the Legislative Assembly.
Mr Attorney General, I know in your diary you've met twice on this issue up until September. So I've looked at your diary from April to September. There are no, there's nothing available beyond September. You've met with obviously representatives that Mr Greenidge brought, ACORN, Equality Australia, I think on the 27th and the 6th, and then you met with religious leaders, I understand, on the 1st of the 8th. Have there been any other...
Mr Donnelly also brought some concerned parents in to talk to me as well.
Is that in the diary disclosure?
Well, it should be. If it might have been.
I don't think it's...
It might be outside the most recent disclosure period, but I'm disclosing it now.
Okay, so there was another meeting
Yeah.
Since September. Okay, so you've
I
had
don't know what date it
three-
was, but I have met Mr
So
Donnelly.
you've had 3 formal meetings about the conversion practices bill with stakeholders. Is that what...
Yeah, one of them was with Better Balanced Futures, and we decided to condense 15 meetings into one. So there was a big contingent of religious leaders in that meeting. In fact, I've had 2 meetings with them, and there were a number
2
of
meetings,
groups.
because in there I can see 1 meeting.
No, I've had
that's
2.
closed. Since September, you might have another one. Is that what you're
Yeah,
saying?
I think that
perhaps
might
I'm
be
not
right.
aware
Yes,
of? Okay.
correct.
I think you're meeting with religious leaders next week. Is that right, Mr Attorney General?
I don't know. I'd have to have a look at
You
my
don't
diary.
know? Okay. Have you had a really good look at some of the submissions in relation from the religious groups and organisations like Women's Forum? Have you met with Women's Forum, by the way?
I'd have to have a look at my diary, Ms Mahalik.
I understand they've requested a meeting to discuss with you the issue of gender dysphoria.
I'd have to look at my diary. I just don't have a copy of it in front of me.
Can I actually discuss with you gender dysphoria? Mr Attorney General, would you say that there is at the moment a rise in gender dysphoria?
I don't know.
You haven't come across any data? Or
I don't have that
any
data.
research in
I
relation
don't have that
to
data
it?
at my fingertips, but I'm happy to take
well,
that on
it's an
notice.
issue that was Mr Greenidge is very keen certainly in terms of transgender, he was keen to make sure that gender and gender rights and so forth was put into this conversion practices or prohibition bill of his own. So I imagine he'd have to be across that. Most of the submissions, religious groups and indeed some, and women's for example, have raised the issue of gender dysphoria. There's been a lot about it in the detail. In fact, Mr. Greg Donnelly had a forum recently in Parliament that I attended where he had family members of women in particular who have suffered from gender dysphoria. You didn't have any discussions in relation to that, Mr. Attorney General?
In relation to which one? You raised
Well, I'm
several
raising
forms.
I suspect that the parents that met with you might have been talking to you about parental rights in relation to the conversion practices legislation that you're proposing. And that is a big issue for parents right now. And the fact that what's potentially being proposed, and certainly the Victorian legislation, if the government chooses to go down the path of the Victorian legislation, does go into the area of gender, and it certainly does go into the area of prohibiting the ability for parents to have a role in counselling their children, or indeed providing support to their children, and indeed providing support through pastoral care as well. Have you had a good look at the Victorian equivalent legislation?
Yes.
And you're across the issues that have been raised there, that particularly by religious organisations, in terms of impacting the practice of religion and the freedom of faith and the ability for parents to have a role in supporting and counselling their children?
I'm familiar with those issues in a general nature. I won't say I've read every submission in respect of them, no.
Well, have you read the submissions from the multi-faith groups that gave a very significant submission?
Some of them.
Well, they actually made a combined. There's one. It's not very long, but they've made a combined submission to make life easy for you, and it actually has a plethora of religious groups ranging from Hindu, Islam, a number of Christian groups, including the Maronites and the Catholics, and indeed Freedom for Faith and Baptist, and there's a whole range of religions there. I would have thought you haven't read their submission in relation to this?
I've got a folder of submissions. I'd have to go back and
Well, hang on, you
identify
just
each
said
one.
you're about to put the legislation in a week's time.
No, I didn't say that.
No, you did. You said something's going to
said
be
shortly.
introduced shortly. So you're ruling out it won't be November then?
I'm not ruling anything in or out. That's a matter for
The
Cabinet.
Premier did say that it would come before the end of the year, didn't he?
Matter for him.
Or did he?
I don't know.
You don't know. You don't know what the Premier's view is
I'll have
on
to go
this.
back and have a
You
look
don't
at
know.
what-
You've not
I'd-
read any of the media
I'd have to have a look
articles
at
where the
what-
Premier has
I'd
said
have to
that
have
he's
a
going to
look.
make
You
sure this bill is
I'd have to
introduced
go
the
back
House.
and have a look at those comments. I've given you an indication that it'll be shortly, and I can't give you a timetable because that's a matter for Cabinet, as you well understand.
Mr Attorney General, back to gender dysphoria, and we have had some very good forums in relation to that recently, where we met some of the families that have had to suffer through horrible stories where their daughters in particular had suffered gender dysphoria, weren't given the necessary support they needed, and are seeking support from the Parliament to understand and appreciate how important pastoral care and proper psychological care is at a time when a young woman in particular is suffering gender dysphoria. I just want to make it clear, have you had any information put to you before you as the lead first officer of the state in relation to that?
Some, but they're all important matters. They will require a considered response, and a lot of the matters that you have put to me are really issues for the Minister for Health.
Ms. Boyd.
Thank you. Good morning, Attorney
Good
General.
morning. How are you, Ms. Boyd?
We are still in morning, aren't we? All just, yep.
Just.
I'm sure you're aware that domestic and family violence experts have raised issues around the current coercive control offence and the related amendments, and proposed that they require redrafting in order to be safe for women and children, and particularly to prevent misidentification. What steps is the New South Wales Government taking to address those concerns?
So I just didn't hear the first part of your question.
That's okay.
I'm having acoustic problems myself here.
That's fine. So domestic and family violence experts
Yep.
have been calling for a review of the coercive control offence and associated amendments, so that legislation that came in last year.
Yep.
They have very big worries that it's not fit for purpose and that could actually cause more harm than it solves. What have you been doing to address those concerns?
Well, I suppose there's two issues, Ms. Boyd, really. One is whether one agrees with the legislation as it went through the Parliament and whether it should have been put through either at all or in that form. And that horse is bolted.
Which horse? The horse of whether or not it should?
Whether it should have been put through Parliament at all at that time, put off for 5 years, or whether it should have taken another form. And that's been settled by the Parliament. The second aspect goes to the implementation of the current legislation.
Yeah. Can I just take you back, though, before that? So we will talk about implementation, but when it comes to the actual form of the legislation, it's been called the most conservative and perpetrator-friendly version of coercive control legislation anywhere in the world. I understand that Labor was, in a position where it wanted to pass something rather than nothing last year, even though the domestic and home violence sector were not in favour of that particular version. And I think we all want coercive control to be criminalised, but now the domestic and family violence sector are saying you need to actually go and review it, and can we please have a better version? Are there any plans to actually amend the legislation before it's implemented?
No, there's not. It'll be implemented in accordance with the legislation, which has a built-in legislative timetable, and it also has legislated a task force to supervise implementation. So it also has a 2-year, I think, 2-year statutory review timetable. That is when it will be, the legislation per se will be reviewed. It'll be implemented in its current form.
There are, coming to implementation, there are very serious concerns around the resources and the time being dedicated to implementation. When this offence was implemented in Scotland, there was significant resources and time spent in training up police, in training up the judiciary to ensure that it didn't have unintended consequences when it came in. I know that in New South Wales we are doing something, and I know that we're doing some form of training, but the domestic and family violence experts are saying it's not enough. Would you be open to delaying the implementation of the legislation or of the offence if we get to June next year and it's clear that we don't have everything in place to avoid those unintended consequences?
I'd have to amend the Act to do that, because
Yes,
I think it has
that's
a
right.
drop-dead start date
It
within
does.
it. I'll be guided by the advice of the department that's overseeing the implementation of it. I don't anticipate there'll be any advice to me that it's not ready. The legislation requires the department to update me on a 6-monthly basis as to its state of readiness or otherwise. At the most recent update, the advice was that it's on track, but if I formed the view that there was some horrendous shortcoming in the implementation that made it inadvisable to proceed with it, of course I'd be prudent to
Will you
say
be
that I
guided
would.
by the domestic and family violence sector, though, or are you looking
I'll be
at...
guided by the department,
Right.
and they are in consultation with the domestic violence sector, as am I open to whenever they wish to meet with me, and I'm in conversation with Minister Harrison about this. Some of the domestic violence groups are on the implementation task force.
Yes.
So there's plenty of opportunity and many avenues for them to express their concern, but at the end of the day I don't want to give a false indication to any one or any group. It'll be the department that will provide me with the advice and that I will rely on.
But there is a difference, isn't there, between consulting with and listening to? And I think what I've heard from the domestic and family violence sector, for instance, in relation to being so-called consulted on the version of the police training, is that their advice is not being taken up. So we can say that we're consulting, but if we're not actually listening to the decades and decades of experts' advice and experience, then it's not really real consultation. What are you doing to ensure that domestic and family violence frontline workers, experts and victim survivors are not just being heard but listened to in the process of implementing this offence?
Well, I'm guided by the advice that I'm receiving from my department about that.
The Domestic Violence New South Wales Forum in May 2023 pulled together a significant sort of chunk of the domestic family violence sector, and there were 6 calls made out of that forum, and they were focusing particularly on the issue of misidentification of the predominant aggressor in domestic and family violence matters, which is a particular concern, as you would know, in First Nations communities. They asked, their number one call was that the Attorney General commission the New South Wales Law Reform Commission or a special task force to undertake a broad review of the Crimes Personal Domestic Violence Act and other associated legislation in order to address wide-scale systemic misidentification. Has anything been done in response to that call?
So the New South Wales Government recognises that in some cases victim survivors of domestic and family violence may be misidentified as the predominant aggressors in those relationships. We acknowledge that domestic violence in New South Wales and the sector have called for action to be taken to address and prevent misidentification across the service system, including in legal and child protection settings. The government notes that misidentification has been highlighted as an issue of concern in domestic and family violence research, particularly for First Nations women, women from culturally and linguistically diverse backgrounds, women with disabilities and or mental health issues, and women with substance abuse issues. The government is carefully considering the issue of misidentification and assessing whether any policy, procedural or legislative reform or further education and training are needed to address and prevent misidentification. Stakeholders, including DV New South Wales, will be consulted throughout this process.
So just going back to what the demand was, that you undertake a broad review of the legislation, is that actually happening? Is that what that response is saying?
What I said was we're carefully considering the issue of misidentification and assessing.
Okay, but the department's doing that, not a task force or the Law Reform Commission. Right. An associated issue, and again something that is really prominent in First Nations communities and with First Nations victim survivors, is the phenomenon of going to the police and making a claim in relation to a domestic violence situation, and then subsequently withdrawing that claim. That is done by victim survivors who then get scared. In the case of First Nations victim survivors, it's often because they're fearful that their perpetrator, who they just want to stop the violence, is actually going to end up in jail. And we all know about the absolutely horrific levels of deaths in custody for First Nations people, or that they think their children are going to get taken away from them because of the systemic racist biases against them in the family justice system. But we also have a situation where men in particular, or whoever the perpetrator is, will also use false accusations as a way of controlling in a relationship and using that as a form of systems abuse. So it's a very complicated area. What is the government doing in terms of identifying the hotspots where police are just not understanding what they're supposed to do in those situations and who the primary aggressor really is, particularly in those kind of hotspot areas where that's happening?
So I'm aware of those concerns that have been raised about police arresting and charging First Nations women who are victims of domestic violence if they retract their complaints. I want to thank Mr Lawrence for being one of the people that brought that to my attention and to the attention of the House.
And let me make it very clear that the domestic family violence sector is not calling for any legislative or procedural
Yeah.
reform here. They're calling for training.
Yeah.
What is because of that danger of it
Yeah.
picking up people who are
So-
doing systems abuse. But what are you doing in terms of training of those police?
So the training of police is a matter that's within the responsibility of the Minister for Police, but I've directed some time ago DCJ to facilitate a discussion between the Aboriginal Legal Service, Legal Aid and the New South Wales Police Force on this and related issues.
Why wasn't Warringah involved in that and domestic family
Well, that
violence
might well
sector?
be in due course, but the first step is for that discussion to occur as I've just described it to you.
Thank you.
Okay, opposition question.
Thank you very much. Prior to the state election in March, the New South Wales Coalition Government announced they would provide victim survivors of domestic violence with access to first home buyer support and interest-free rental bond loans. These reforms would help remove significant barriers for those escaping domestic violence. Has the Labor government also committed to these initiatives in their budget?
I'd have to take that on notice.
Yes, I can answer.
We have? Okay,
Yes,
thanks, Anne.
yes.
Yes.
And can you outline how much has been allocated?
I'd need to take that on notice, and that certainly sits with the Minister for Domestic and Family Violence, Minister Harrison.
Do you recall, Attorney General, the 21-year-old mother, Mackenzie Anderson, who was allegedly killed by her 22-year-old ex-boyfriend in Newcastle on the 25th of March 2022?
No, not really.
Okay. I'll outline some of the details. So her ex-boyfriend had been released from prison on parole weeks before she was allegedly killed, and he is also the subject of an apprehended violence order. Do you believe that the domestic violence electronic monitoring program is an important way of providing safety for women subjected to violence from their ex-partners?
That would be one of the programs that are run through corrections, wouldn't it be? Yes. Well, the answer is yes, and it's corrections run the program.
The previous New South Wales Coalition Government committed $20 million to expand the state's electronic monitoring devices for high-risk domestic violence offenders following the Mackenzie Anderson alleged murder. This meant that the state would receive 200 more electronic monitoring devices in efforts to protect victim survivors. How much money was allocated for electronic monitoring of offenders in the New South Wales budget?
Yeah, again, it's Minister for Corrections, but if we can get you that information before the end of today, we will.
We will, yeah.
We will? Yes. We
And
will.
if you can also outline, based on how much has been allocated, how many bracelets that would cover.
Sure.
Attorney General, does the government prioritise women's safety?
Yes.
Minister, we have discussed previously, and I'm sure you would agree, the importance of ensuring that people are aware of the law that's being enacted, but more importantly, that we see that these laws are being enforced. Is that correct?
Yes.
Can I ask who is responsible for the community education campaign about the new coercive control laws? Is it your department or that of police?
It's, I'm happy to assist. It is under the umbrella of and the mandate of the Coercive Control Implementation Task Force, which I chair, with the input of a number of reference groups reporting to the Implementation Task Force, which in turn have a number of community groups represented. There is a training program which is focused on the implementation with a budget allocation of $5.6 million to support implementation of the reforms.
And that's 5.6 million, you said?
Yes.
Yep. And how much of that is that all for communication to the public, or is it broken down?
It is training, education, and for the purpose of awareness with a two-phase public education program.
Okay. Attorney General, coercive control includes seeking to control the choice of others. The New South Wales Government website indicates that coercive control includes, and I quote, exploiting a person's medical condition to make decisions about their care, to disempower or control them, end quote. Voluntary assisted dying laws commenced in New South Wales on the 28th of this month. Has your office assisted with training of those who will be handling requests for voluntary assisted dying to ensure that they can identify coercive control and that all requests to die are made freely?
Has my office
Or
done
your
that?
department or your...
I'm not sure. I don't know. Take that on notice, or do you want to? No.
Take it on notice.
Take it on notice.
Yep. Take it on notice.
Thank you very much. Attorney General, can you provide an update on the rollout of the education campaign to support the reforms to legislation regarding the sexual consent laws in New South Wales?
I'll have to get the department to update you on that if we can.
Yes, a large amount of work has already been completed, but we can certainly provide an update on notice.
Yes, we can do that this afternoon. Attorney General, are you concerned about the effect of the High Court decision in May this year, and it's the matter BA versus the King on women's safety?
Yes.
Will you be supporting the Shadow Attorney General's introduction of legislation to close the loophole in regards to break and enter laws that were exposed during this judgment?
No, we won't. And I've already... when Mr Speakman was the Attorney-General and I was Shadow, we had a policy of no surprises, where we respected each other greatly, and I still do. I share that same policy now with Mr Henskins, the Shadow Attorney-General. So we've already, some weeks ago, met with him and told him that we won't be, that the department have expressed some concerns about in respect of his legislation, particularly in respect of unintended consequences that may, in fact, adversely affect women and domestic violence victims. We've given him an opportunity to meet with the department to have those concerns expressed directly to him. I stand to be corrected, but I believe he has taken... No, maybe he hasn't. Yes, he has. He has met with the department and they've explained that to him. The question was, will we be supporting it? No, but we'll be bringing our own legislation in respect of BA and the King.
And what's the time frame for that?
I don't know.
Okay.
But we're not mucking around with it. It's not on the back burner. It's something that we want to address readily.
But you don't have a time frame?
No.
Attorney, changes were made to the New South Wales Trustee and Guardian Act to allow the trustee and guardian to determine the fees payable in relation to their functions, in addition to the fees prescribed by the regulations. You agree with me that when fees are set by regulation, they are transparent, and most importantly, the Minister sees the fees charged and approves them?
I'm not sure whether that's the case here. Yes, they should be transparent. Whether in all circumstances the Minister has the power to set the fees, or whether there are some delegations in respect of some regulations where it doesn't come to the Minister and there's another fee-setting mechanism, I'm not sure.
Okay, but there is still oversight if it's done by regulation. It's a more public process.
It can be.
Yep.
Depends on what the terms of the regulation are.
Whereas when the trustee and guardian can determine its own fees, then there is the ability for a CEO to cover any shortfalls in his agency budget by increasing fees, perhaps in an unreasonable manner.
If what you put to me is the case, then as it follows, yes.
So what protections are there to stop price gouging of New South Wales consumers by the trustee and guardian unilaterally increasing fees?
Unless somebody has some advice about that, I'll take it on notice. But if you're talking about proposed changes to regulated fees charged to customers are part of New South Wales Trustee and Guardian's overall plan for financial sustainability. They relate to fees that have not changed since 2016, and they aim to balance fairness, equity and market forces. The revenue from these changes is intended to strengthen Trustee and Guardian's capacity to provide better outcomes for customers by enabling it to manage the growth in demand and complexity of the services it provides. Trustee and Guardian provides discounts, fee reductions and waivers to customers who have limited income and assets to pay for services. A discount is also provided for document storage fees for some New South Wales seniors card holders. Trustee and guardian is authorised under its governing legislation to waive, remit or reduce fees where there is clear evidence that those fees would cause extreme hardship or would be inequitable. The first changes to fees which impacted clauses 11 and 28 of the regulations commenced in January 22. These included changes to fees for wills and estate planning services and managing customer investments. Additionally, Trustee and Guardian have provided me with a briefing on proposed fee changes. Fee changes will not proceed at this stage due to cost of living pressure considerations.
I appreciate all the detail of the fees, but the question actually went to the mechanism and risks inherent in the mechanism which has been changed by your legislation and what protections were in place. And I note that changes to both the Civil Procedure Act and the Dormant Funds Act also permit an increase in fees by regulation. And do you agree that there is here a similar risk that cost of living pressures will not be taken into account and fees could rise unreasonably?
Yeah, I'd have to take some advice on that. I just don't have the provisions of those mechanisms in front of me unless somebody else wants to.
Well, I suppose the question that we're asking is why are you seeking powers to allow for extra cost to be imposed on New South Wales citizens under these new changes?
Yeah, I've just said I'll just take that on notice.
Thank you very much.
Thank you, Attorney General. Are you aware of comments by the Director of Public Prosecutions that her office frequently terminates prosecutions involving Indigenous complaints because existing trial processes are not culturally safe?
Yes.
You are aware? Were you consulted before these comments were made?
No.
Are you concerned by the implications of the DPP statement?
I do have a note on that. The DPP raised that with me in a meeting, and we'll be discussing that further. In relation to that matter, I would imagine that judicial officers are aware of those comments, and they can take those matters on board themselves and address any of those issues.
But what actions have you taken to ensure that community is safe?
Well, I'm going to be having a further meeting with the DPP to discuss that and any suggested amendments.
Okay.
But I do know the DPP is independent of me. I can't give her directions, but we will be meeting to discuss that again.
And just to clarify, you were or were not concerned by the statement?
Of course I was concerned, yes.
And have you relayed that? Did you relay that to the DPP?
Just a little bit.
Yes.
How many JPs are registered as court-appointed questioners?
I don't have that number at my fingertips. Take that on notice.
We can provide that today, though.
Yep. And what has been done to promote the uptake and ensure vulnerable victims are given the chance to give their best possible evidence in court?
I've got a note on that. I might take that on notice, Ms McLaren.
Mm-hmm. Attorney General, one of the initiatives that was welcomed by the Disability Royal Commission is the expansion of the program to divert people with cognitive disability from local courts into the NDIS, where they are supported. My understanding is of the 155 courts we have, only 6 of these have the diversion program. Can I ask what you're doing to expand this statewide?
Yeah, I'll take that on notice.
Mm-hmm.
As our First Law Officer, Attorney General, are you engaged in any discussions about treaty?
It's been led by Minister Harris.
So, and you're involved in the legal discussions in relation to treaty?
Not at this time.
Do you anticipate that you will be?
Yes.
Would a treaty require an amendment to the New South Wales Constitution?
That's a matter for the Minister for Aboriginal Affairs.
So the Minister for Aboriginal Affairs will decide if there's an amendment to the New South Wales Constitution?
Hopefully Aboriginal people will. He'll come up with, in consultation with a number of ministers, what the model will be. So I don't know what that.
So it may or may not?
Let's wait and see.
Wait and see. How would any treaty interact with the Aboriginal Land Rights Act of New South Wales?
We haven't arrived at that position yet.
So we don't know anything yet?
Because that matter should probably be addressed to the Minister for Aboriginal Affairs.
Okay. So, First Law Officer, you're not aware of any of these issues?
Don't put words into my mouth, please.
Just trying to clarify, sir. Just trying to clarify. Can I take you to a very different issue?
Sorry, I didn't hear what you said then. Someone coughed.
Sorry?
I didn't hear that.
Oh, sorry. Can I take you to a very different issue?
Sure.
Can I take you to an issue at one of our busiest local courts in New South Wales, that is Burwood Local Court. This may not seem like a big issue, but it is a major issue for the elderly, people with young families and prams, and anybody with a disability. As at yesterday, the lift which failed around the 9th of September is still not functioning, which has created enormous access problems at this local court for 2 months. I gather there have been numerous inquiries with senior court staff, still no indication as to when the lift will be back in action. Are you able to provide any update, or are you able to escalate this matter in any way?
Happy to escalate it. Sure.
Thank you, because I recognise it doesn't rise to the same issues that you always deal with, but it is a significant issue.
It does if you're disabled. It's very important. So thanks for bringing that to my attention.
No, absolutely. I understand from answers to my colleague's question that you are intending to introduce a conversion therapy bill, but is there a date as to when that will be introduced?
No, not yet. Not until Cabinet decides it.
Okay, and so are you able to provide any details of the outcome of the consultations that you held in relation to that?
That was led by the department, so I'm happy for you to...
Thank you.
Yeah. Consultation, what consultation have we done with gay conversion?
Considerable consultation on that. Your question
was...
was...
Sorry, could you speak into the microphone? It's very hard to hear.
Your question was...
The outcomes of the consultation that you held in relation to your proposed conversion therapy legislation.
The outcomes?
Yes.
That would be reflected in the bill that the government brings
and
forward.
So can you share any insights from those outcomes?
Okay. So I think... I guess the outcomes of the consultation involved a range of face-to-face meetings with the stakeholders. I think the stakeholders' views are fairly well expressed in the submissions that they made. I'm not sure that the face-to-face consultations shed any further light on the different views in the community about the issues. I mean, those views are fairly well rehearsed in the submissions, I think.
And how were the stakeholders who were consulted determined?
I'm sorry, I'll need to take that on notice. They would have been determined by an assessment of who made written submissions in relation to the matter, who we know, the agencies the organisations that we know would have been interested in the matter, and we would have had discussions across government about...
Can I take you back one step? Because it's my understanding that there was not a public call for submissions. Rather, stakeholders were identified and asked to submit.
You're right, I misspoke.
Is that
Apologies.
the usual practice for a law reform matter, that only selected members of the public are invited to comment on a proposal?
Proposals of this nature are...
Which nature, sorry?
Proposals of a law reform nature, the process for consulting on them and developing them is designed on a case-by-case basis for each proposal. There isn't a standard approach. Sometimes we release discussion papers publicly and seek public written submissions and have face-to-face consultations. Sometimes the matters are referred to expert bodies like law reform commissions. Sometimes law reform is undertaken on a more targeted basis, including...
Could you give me an example of the last time that a consultation was undertaken on a closed, private, targeted basis?
There is a reasonably significant list of those. I can take on notice some examples and provide them to the committee. Yes.
So therefore my question remains,
It's
how
not
was
uncommon.
the target list established? How was the targeted stakeholder list established?
So we would have attempted to reach all the stakeholders that we understand to have been interested in the issue. We would have talked to colleagues in other government departments, and in this case, the the Ministry of Health would have been involved in the process, and they have been involved in the work to reach out to community groups in their portfolio. We would have discussed the issue with the attorney and his office. The aim is to get a broad range of voices and to ensure that people with views on the subject have an
Not
ability
a public range of voices, just a targeted private range of voices.
It was a fairly extensive consultation
About
in this case.
140 submissions received, I think, as well.
Yes.
No, I'd be very interested in that list of other examples that I hope you're able to provide.
Absolutely.
Last question. Will you also, Attorney General, be introducing your own version of the Equality Bill? Equality Legislation Amendment Bill, I apologise.
Perhaps that's a matter for Cabinet, but just going back to an earlier question, I was probably overly cautious. I am now able to advise that the conversion therapy bill will be introduced in the coming weeks of Parliament before the end of the year.
Thank you.
Chair. Thank you, Mr. Chair. So I'll just on what you
So,
just
Mr.
announced.
Chair, could I just get an indication of the time remaining, because we just want to clean up some of these
You've
questions on notice as well.
You'll get time. Don't worry.
Yeah,
I didn't ask
Don't
you
worry.
to
Don't
ask
worry,
me.
Mick.
We can do it in,
Do it in the
we can
government
do it in
section.
government question
Do it in your
time,
section.
Right,
Okay.
okay.
from quarter to 1:45.
Okay.
Thank you, Mr. Chair. Thank you, Attorney General. Can I just, you've just clarified that the conversion practices or therapy practices prohibition bill will be introduced in November. Just want to clarify that.
Yep,
You've
yes,
just
it will.
confirmed that, right? So an hour ago you didn't know, or 45 minutes ago you weren't sure, but you've just
No, I was
clarified
being
that. The first officer of
as
the
a-
state has now
I
finally got some
was
information in
being
the next
a bit
last 5 minutes.
cautious as to my
No, I think
authority
you're being
to talk.
misleading. Are you saying that you didn't know 45 minutes ago that you were introducing the legislation in 2 weeks' time or in a week's time when the November parliamentary session resumes?
Keep going.
Can I, on that bill, and given that you're introducing it, you must have a whole stack of knowledge about it, Attorney General. The member for Sydney's conversion practices prohibition bill specifically talks about suppression practices around gender identity and removing the or limiting psychological and pastoral care in relation to that. Is that what's going to be the same case with the government bill? Will you also be referring to gender identity?
You do know that I don't talk about Cabinet matters outside of Cabinet.
Well, you've just told us that the bill's coming in a week's time. Okay. Can I ask you, Minister, about the GILIC competence? You're aware of that?
About the...
GILIC?
I can't hear you.
GILIC competence? G-I-L-L-I-C-K competence? You're aware
No,
of that?
no.
Terminology? You're not aware of that terminology? Okay.
No.
Well, let me explain that to you. The member for Sydney, in his conversion practices prohibition bill, wants that competence to be clarified within the Children and Young Persons Care and Protection Act to ensure that a young person over the age of 16 can consent to their own medical treatment as an adult, effectively as an adult. It's a pretty important competence to understand. Is that going to be put into this legislation, reference to it, or you don't know? Or you can't disclose?
I refer you to my earlier answer.
Well, you don't even know what the competence is.
I'm aware of the
Just a bit
concept. I just
disturbing.
wasn't
No, you
aware.
just said to me you didn't know.
I wasn't aware of the term.
You didn't know. Okay. It's a pretty significant concept to be aware of as the first officer of New South Wales. It's
about questioning, not insults.
I'm not insulting at all, Mr. Chair.
Order.
I've clarified that he doesn't
we're
understand
progressing
it.
quite well. I think the Attorney General can look after himself.
Yeah,
Mr. Lawrence.
I think he can. He doesn't need the up-and-coming
giving us-
Attorney General to help him, okay?
He's giving
He
as
doesn't
good
need
as
an
he's
up-and-coming.
getting,
The two
so
up-and-coming ones are over
I
there,
don't
aren't
think
they?
he
Aren't they,
feels-
Mick? You watch
he
your back,
doesn't-
mate.
Could have been you. Could have been you before you went to the dark side too, Tanya.
Order.
I'm very happy where I am. I can tell you that.
We're happy with it too.
Can I? Well, are you? Because I get to answer. I get to ask the questions now, Mick. I get to ask the questions now.
Oh,
and I know you too well. I'm afraid.
Good to
so
see
can
old
I
friends.
put to you, Mr. Chair, putting all the fun and games
Mr.
aside.
Holbrook, you're supposed to come to order when I call you to order.
Thank you, Mr.
Regardless of how funny it is.
Mr. Chair, can I, because this is a very serious matter to
Still not
me
working.
and to many parents out there, this issue about the Gilly competence, I want to put to you, if your government is intending to put it into legislation and you're not going to provide that detail now, but if I can put a scenario to you,
More role
your
play?
16-year-old daughter comes home and tells you, Attorney General, that she wants to become a man. And she decides that she's going to proceed with cutting off her breast and removing her uterus, you don't think that you as a parent would want to have something to say in relation to that?
That's a hypothetical question. I'm not here to answer hypothetical
No,
questions.
it's a
like
fair question because it's all about the Gillick competence, which is what the member for Sydney is proposing in his legislation. You're not ruling it out. Will you rule that out then? That allowing that level of consent for a child at 16, where they no longer need their parental consent in relation to such serious medical treatment like sexual alteration surgery, where they remove their breasts or they remove their uterus. I'm asking you, will you rule that out in your bill in a week's time?
No, I'm not ruling anything in or out. You can wait for the legislation and see what's in the bill when it's second read.
Okay, thank you.
Thank you.
Thank you, Chair. Good afternoon.
Morning, Ms. Family.
Attorney
Oh, is it
General.
afternoon? Yeah? Yes, it is.
Afternoon. Yes, it's afternoon.
Time flies when you're having fun.
I want to just ask a few questions about the two-strike diversionary scheme. No doubt different questions to what was asked earlier today. So the two-strike diversionary scheme, what additional work did Labor do on it? I understand it was largely formulated under the coalition government. Is that right?
Yes.
Did you do any additional work or consultation?
No, I'd have to get some advice about what went on behind the scenes at the departmental level, and I can't speak for what happened within health. My understanding is that the scheme that we adopted was pretty much what the earlier government had put into place.
So did you satisfy yourself as Attorney General that that was the best scheme to introduce at the time? Did you do your due diligence and homework around what you were introducing?
Well, as I explained to earlier, Ms. Cartwright, the government had a decision to make as to whether to allow this scheme to come to fruition with all the work that had been done by health and by police and all of the bona fides that they put into its preparation, or whether to park it and to see whether we should just proceed straight to our long-standing commitment to a drug summit and to see whether we would come up with a different scheme. And the government's view, on balance, was that given all the work that had been put into it, the fact that inherently it made sense and was good policy, that we would proceed with it.
Okay, so are you aware of the way in which it differs from the ICE inquiry's recommendations around a pre-court diversion scheme?
No, it's been a while since I've looked at those recommendations.
So there's some key differences. I mean, first of all, the ICE inquiry commissioner recommended, firstly, more like a decriminalised model,
Yep.
or a decriminalised model, and if that was not able to be stomached by government, an alternative, and the alternative was a three-strike scheme, in fact.
Yep.
So 3 strikes plus very, very strongly recommended that or suggested that police not have discretion, that it be mandatory referral, that it be legislated, it be 3 times. So it's
it veers quite strongly from those recommendations. So as Attorney General, does that concern you? Do you understand why police discretion is an issue in this situation?
Potentially, yes, it is potentially an issue, but we had a binary choice, and I've described to you what that choice was, and we decided to implement the scheme as it was, given the work that had already been done on it, and not have to undertake months more work and to
So
check
really,
out.
like Labor so far in government hasn't really done anything, because you've just implemented what was started and agreed and committed to under the coalition government. The work had already started. The $500 million has already, not been spent but allocated. The Commissioner and the Chief Health Officer were going to report back anyway, and it was due to start on the 1st of July. So really, Labor hasn't really done anything.
Well, it's not a new initiative, but what we have done is to realise and to join with the former government, if you want to characterise it that way, that that it's time to look at the health issues and not just the narrow justice issues that arise with drug taking and possession. So I think we should be given credit for not simply sitting back and saying that we will wait until a future date, that we'll move now on a scheme that had some work done on it already.
And you didn't, so it wasn't within your power, or there was no mood to have a look and see whether it needed to be improved from an Attorney General's perspective?
I was satisfied with the work that had been done, particularly the fact that we'd got buy-in from the police, which is hugely important.
Did you get briefed by experts, particularly maybe First Nations groups about it? I mean, this is where police discretion becomes very concerning, doesn't it?
It can, from some people's points of
Did you
view.
get briefed?
No, because the decision...
So the decision
I've
wasn't
been-
made
I've been
largely
through-
by
I've been
this
through all-
government, it was
I've
made
been-
by the coalition government.
been
That's
through
what
all
this
morning
diversionary
already.
scheme is all
I've
about.
been through this scheme uphill and down Dale already this morning, and I don't really have much more to add.
Well, I'm
to
asking
what I'd say.
very different questions to
Not
what
really.
the coalition member asked. Can I just ask one more question around the detail? So it's two strikes. Over what time period do those two strikes refer to?
I don't know that they have an expiry period, do they? I don't think so.
So what, over 20, like the whole...
I'll have to check that.
Yeah, I'll have to
On
check.
notice, I don't think it does.
I don't think it does. I think in the adult life of a person, you can't get more than 2 strikes. We'll take that on notice, but I think that's how it works.
Okay, I'll throw to my colleague.
If you need a bit more.
No, all good.
Okay. Thank you. Attorney, the no body, no parole laws, they were introduced, or do you accept that they were introduced as a reaction to the Dawson conviction last year?
You'd have to ask the former Attorney General who introduced the legislation.
Are you at the moment considering reviewing those rules and those laws?
Not at the moment, no.
Do you accept that? So are you satisfied with the potential unintended consequences they may have on current people currently serving terms of imprisonment when their parole comes up?
I'm open to people of whatever capacity coming to me to express their reservations about that. And so far, none have. But
I think maybe.
in fact, I'm not even sure that it's my act. Is it?
No, it's the role of the commissioner can make recommendations
Yeah, but the crimes
around around that. But if there was, evidence that or material put to you and the commissioner that these laws are impacting potential parole really unfairly, would you be open to having a look at the laws and reviewing those?
I've got a standing attitude, if you like, Ms. Higginson, that in respect of every law that I'm responsible for under the Allocation of Acts Act, that principle applies. So yes.
Thank you.
But it'd have to be pretty serious, I've got to tell you. It'd have to be serious unintended consequences.
And I would suggest strongly, Attorney, would you agree that holding somebody in prison when they shouldn't be there is pretty serious on every occasion?
As a bald proposition, yes.
Thank you.
And if you've got some concerns, I hope my door's open for you to come and see me, by the way.
Thank you. Your diary disclosures don't show that you've met with the families of Evelyn Greenup, Clinty Speedy Durow and Colleen Walker Craig, or their advocates from the Jumbunna Institute. Have you considered meeting with them?
I don't know if I've received a request to meet them, but I'm happy to take that on notice and see if I have.
I've written to you about a request for an ex gratia payment for the families, and I haven't received any response to that. Are you considering an ex gratia payment of some sort to those families?
Yes, so the way ministerial correspondence works, and sorry if you telling you how to suck eggs, it doesn't come directly to me first. It goes to the department first. They prepare a brief and it gets to me with advice. So if they've written to me, and it'll get to me in due course. But
And so what's your view in terms of an ex gratia payment to those families?
That's not appropriate for me to comment on specific requests from private individuals in a forum like this.
Opposition.
Thank you very much. I just have a couple of questions. How many times has the Commonwealth Attorney General's meetings been held?
In what time frame?
Well, since you've become Attorney General.
2.
There's been 2?
2. April.
Yes.
Perth, and then, yep, 2.
And have you attended both of those?
No, I attended the first one.
First one.
The second one I was overseas with my family. Happened to fall in school holiday time.
Yep. And when's the next one scheduled?
1st of December.
Okay, thank you.
And unless there's a disaster, I'll be at that one.
I just have one question. I note from your diary, Minister, that you had a meeting on the 14th of September with a number of people, including Ms Isles from Violet Co-Legal and Consulting, to discuss sexual assault law reform. I wondered whether you wanted to share with us any law reform you were considering in the area of sexual assault.
I'm not sure how much I can or should say publicly about that matter. Ms Isles, although she has raised these issues publicly, I'm just careful to not intrude on any confidences, but one of the issues that she has raised, and I'm happy to canvass it now because she has raised it publicly, is, amongst other things, whether there should be a legislated positive duty of care, if you like, or it's how she expressed it, or a positive duty imposed upon the police to legislatively require them to investigate any and all complaints that are made. That's one of the things that she raised, amongst others, and we're looking into those concerns. It was a good meeting. I thank her for coming forward. She's been very brave. She's had some very positive meetings as well with the police at a very senior level. The meeting that she attended, that she called for and that we facilitated in Parliament, was also attended by the Minister for Police and Minister for Women, Ms Harrison, along with some of our senior staff, and we're looking at those issues very carefully.
And you were persuaded by that, or it's still under consideration?
It's still under consideration.
Okay, thank you. I've got no more questions.
No more questions.
But I do have to say, I was very heartened to get a briefing from the police about that, and they have really engaged with Ms Isles at a senior level. I'm not sure that that they'll end up agreeing wholeheartedly with each other, but there's been some very, very concerted efforts and good-natured efforts made to understand her position and to facilitate them where possible.
Great, thank you.
All right, I think, Attorney, we've come to the end of our questioning at the moment. You said you had some
Yeah, I might hand
items
over
you
to the
want to put on the
Secretary,
table.
Mr. Chairman.
Yes, if I may, in response to the question about court-appointed questioners and the number of JPs who have been trained, I can indicate that some 51 JPs have been trained and are available to do the work, and over the next month, training for another 13 JPs, it is anticipated will have been completed.
Okay. Any more?
That's it for me. Any hard copy?
Mr. Campbell.
Oh, which one? That one? I just gave to Paul.
Yeah, the money,
Walden?
the justice
Read the whole thing out. Okay, here we go. All right, pre-court diversion. The question, I think, Mr. Chairman, was New South Wales Police consulted or did it provide any advice on impact on road fatalities? New South Wales is not decriminalising drugs. It remains an offence to possess and use illicit drugs. New South Wales is not changing drug driving offences. It is also still against the law in New South Wales to drive with the presence of any illegal drug in your system or to drive under the influence of illegal or prescription drugs. The pre-court drug diversion scheme simply replaces, where appropriate, court appearances with penalty notices for people detected with small quantities of drugs for personal use and possession. Currently, most people who commit low-level drug offences receive low-level penalties from courts, such as fines. The scheme was developed jointly by the New South Wales Police Force, New South Wales Health and the Department of Communities and Justice. Careful consideration has been given to the parameters for the scheme, and police support the rollout of the scheme. Second question, is there going to be a public education campaign for the scheme, particularly, for example, for people living close to the ACT border so that they understand the differences? Answer, a communications strategy is currently under development in preparation for the rollout of the new scheme, including information to be provided to both the general public, for example, on websites, and to penalty recipients. It will include address communications requirements for any specific audiences, including by location. This would include messaging around the ACT arrangements as distinct from the new scheme in New South Wales. It is anticipated that the communication strategy will be developed before the end of the year. Question 3. What are the other implementation details of the reforms? Answer. A cross-agency working group is overseeing implementation planning for the new drug court diversion scheme to commence from early 2024. The group includes the New South Wales Police Force, Ministry of Health, Revenue New South Wales, Department of Communities and Justice, the Cabinet Office and others as required. It meets fortnightly and is well established. Implementation activities overseen by the working group and being undertaken by agencies to prepare for the commencement of the new scheme include, but are not limited to, developing a communication strategy for the rollout of the new scheme, including information to be provided to both the general public, for example, on websites, and to penalty recipients, statewide police education and training, noting that the scheme is an extension of the existing scheme and that the New South Wales Police Force use at music festivals, changes to the IT systems across relevant agencies, including Police and Revenue New South Wales, engagement of the health intervention, service provider and service specifications, legislative and regulatory changes, noting, of course, in October 2023, the Justice Legislation Amendment Miscellaneous Act 2023 inserted Section 23 capital B into the Fines Act 1996, which facilitates the scheme by allowing completion of certain prescribed activities to be treated as payment of a penalty notice. Development of the form of the criminal infringement notice and information provided to the penalty notice recipient about health intervention. Engagement with stakeholders such as Legal Aid New South Wales to support vulnerable penalty notice recipients, and a handwritten note that says, I think the working group will also monitor and review the rollout of the scheme. Raising the age questions and meetings. What meetings are occurring on raising the age? Answer. A meeting to discuss raising the age is confirmed for this Wednesday, 15th November 2023, with the following attendees: Minister Jihad Dib, Minister Rose Jackson, Minister David Harris, James Clifford, Aboriginal Legal Service, NSW ACT Limited, Lucy Tierney, Aboriginal Legal Service, New South Wales ACT Limited, Jonathan Hunya from Public Interest Advocacy Centre, Henry Rahendra, New South Wales Teachers Federation, Ben McAlpine from NCOS, Jeffrey Winters from Just Reinvest New South Wales, John Lehar, ABSEC, the New South Wales Child, Family and Community Peak Aboriginal Corporation, Sarah Marlin from Community Legal Centres New South Wales, Demia Hayden, Change the Record, Emily Mayo, New South Wales, Raise the Age. Pre-court diversion, what is the expected success rate of the reform? This will be taken on notice. What is the review mechanism of the reform? The New South Wales Bureau of Crime Statistics and Research will evaluate the scheme. Due to the time needed to monitor the impact of the implementation of the scheme, the complete outcome of this evaluation will take 3.5 years. However, data monitoring can commence quarterly, and the initial effects of the scheme on the issuing of cans, SINs and cannabis cautions will be evident after about 1 year. What is the cost of rehabilitation beds as part of the pre-court diversion scheme? This is a matter for health. It can be taken on notice. It will be taken on notice. What is the timing for implementation, including the exact date for commencement? The scheme is expected to commence in early 2024. An exact date will be confirmed in due course. Question: If an offender in regional New South Wales receives tailored health intervention under the scheme and that intervention requires rehab treatment but the rehab bed is not available, what will happen? Answer: Fine recipients across New South Wales will be provided details for how to access the health intervention, including a contact number so they can call for the service. Where appropriate, referrals to health services may be made. Completion of the intervention will result in the fine being considered paid. Take-up of referrals is not mandatory. Take-up of services is a health matter for individuals, and availability of health services is a matter for health. In relation to drug supply prohibition orders, question: how many magistrates authorised under the DSPO scheme? How many DSPOs have and have not been approved to date? There are 8 authorised magistrates under the Drug Supply Prohibition Order pilot scheme. Since the pilot scheme commenced on 16 May 2022, 16 drug supply prohibition orders have been granted and 1 application has been refused. What is the AG doing to promote the scheme? Answer: the Chief Magistrate is responsible for informing magistrates about the Drug Supply Prohibition Order pilot scheme. In relation to OPCAT, when will OPCAT next be considered by SCAG? Answer: it is anticipated that discussions will continue through SCAG in 2024. Question: is law reform needed to support implementation of OPCAT? Answer: yes. Existing New South Wales agencies with appropriate inspection functions may be designated as national preventive mechanism agencies, and amendments to legislation will be required to support them to ensure that the United Nations Subcommittee on the Prevention of Torture can visit all primary places of detention in New South Wales in accordance with OPCAT. And conversion, question was asked in relation to data on alleged increase in gender dysphoria. We'll take that question on notice. In relation to domestic violence, a question was asked in relation to how much is allocated to DV electronic monitoring in the budget and how many bracelets would this cover. Answer: and also how much is allocated in the budget to support domestic and family violence victims to access first home buyers support and interest-free rental bonds. We will take that on notice. In relation to voluntary assisted dying, the question was asked: has training been provided to those handling with voluntary assisted dying so they can identify coercive control? That is a matter for health and will be taken on notice. 2 to go in relation to New South Wales trustee and guardian fees. Protections, question in relation to protections to stop price gouging by New South Wales trustee and guardian and address any risks inherent in the mechanism which allows extra costs to be imposed on New South Wales citizens. The answer is pending, which probably means it's taken on notice. Finally, in relation to justices of the peace, the question was asked in relation to the number of JPs registered as court-appointed questioners. Answer: 51 JPs are at this time court-appointed questioners. Sorry, I'll answer that again. 51 JPs are court-appointed questioners as at the 20th October 2023. That's it for me, Mr Chairman.
Lift. Can I talk about
And the lift, we can,
The
and the
lift.
lift. at the
Burwood Local Court. Lift. So look, if I can advise that the lift was initially repaired on the 9th of September, but it broke down again. The control panel was the reason for the second breakdown. The parts have been sourced for the control panel and it will be prepared next week. Can I just say, having not interrogated this matter closely, it sounds like the lift is old, and if it's having running issues, we'll see whether there's an issue around replacement, which obviously would need to be factored into minor capital works.
Thank you very much.
And I've just got two more quick ones. The shared equity scheme budget, I think Ms McLaren-Jones, you asked about that. It's $13 million for 23-24. And the other question was around the Justice Advocacy Service Diversion Program, which is delivered by the Intellectual Disability Rights Service. That's currently operational in 6 New South Wales local courts, so Downing Centre, Parramatta, Blacktown, Penrith, Gosford and Lismore, and it was also identified in the Disability Royal Commission as a very good service, so that'll be considered by New South Wales in developing its response to the 222 recommendations.
Thank you.
All right. If there being no government questions, I don't see you chafing at the bit. Thank you very much, Attorney, for coming today. And,
Can I just thank everyone on the committee for your courtesy and consideration and piercing analysis.
Thank you. And we'll now break until 2 o'clock.
Thanks, AJ.
If you're okay.
Thank you very much. Could I ask if the Minister or the Minister's Office, or sorry, Attorney General or the Attorney General's Office, has ever requested specific public servants to fill DLO positions in your office?
No.
I'll move on, just clearing, as we said before, admin question. Could I ask when the last review of the merit program was done?
That's a question, I think, for Ms Campbell.
It is indeed. I'll just look up my note to see, hopefully, if it's in there. More detail. Doesn't say, but I'll come back to you.
Okay.
Yep.
Are you taking that on notice, or...?
No, I'll come back during the session.
Because I'll have a couple of others just in relation to whether or not the program's been reviewed and some of those that information as well.
Okay.
How many days a week is the drug court in Dubbo sitting?
There'll be a test on that. Is it only when there's a full moon?
Unless Stephen wants to add something.
It's 2 days a week. 2 days per week, with capacity to support 80 participants a year.
And do you have any information on the success of the drug court in Dubbo?
Mr Thomas, no, you don't.
No, it's only just started.
Yeah, it is very recent.
There are, of course, evaluations of the drug court overall, repeated evaluations from Boxer.
Sorry, you able to
there
speak up?
are repeated evaluations from Boxer on the drug court overall. It's a successful program.
Do you have any information on the Dubbo one?
In terms of its effect on reducing reoffending
Yep.
or the like, no, it's too early to tell with that court, but there's no reason why it wouldn't perform in the same way that the drug court performs in other places.
And what's the percentage of or reducing reoffending overall that Boxer's put out?
You're testing my memory and I'm afraid I'm failing.
Okay.
Just on the point of evaluation, it commenced operation on the 23rd of February. So typically, to undertake an evaluation, I don't know what the threshold would be, but that is still shy of 12 months. So I imagine we'd want a couple of years of experience to undertake an evaluation.
Yeah.
So to your earlier question, Mr. Thomas helps me out. The 2020 evaluation of the drug court found a 17% lower reoffending rate from those that were not on the program.
So I'm really struggling. Could you put the microphone in?
Yes, sorry, a 17% reduction in reoffending.
And in relation to the Dubbo drug court, and I'm happy for you to take this on notice, since February, just how many people have commenced the program? I'm sorry, been through.
We're happy to come back with that if we can just draw a date. So if we run it to the end of
Till
October,
1st of November, yeah,
right,
that's fine. Or whatever the information that you have
So
available.
I have a figure around that as of the 11th of September, there have been 47 referrals to the drug court at Dubbo, of which 39 have been accepted, and 23 of those accepted have commenced the program. So given the timeframes, it's unlikely that those 23 will have finished the program yet.
And can I ask, what is on what grounds is someone not accepted?
I think we'd have to take that one on notice. Yeah.
Now, on the budget papers, number 3, page 4 to 8, it lists a little over 14 million has been allocated to the expansion of the drug court. What locations does that expansion include?
Yes, we have that. The drug court. So the initial was Parramatta. So at the very beginning, Parramatta 1999, Hunter 2011, Sydney commenced 2013. I'll come back to that. Dubbo 2023. Then there is the Sydney expansion, and I believe, if we can just have a moment, I hopefully have a note on it. Where is it? Yeah, no, it's the LGAs I'm after. Sorry about this. Can I just take a moment?
While you're doing that, I could go back to the question about merit. So it was last evaluated in 2009 and it's currently under review and it's due back in June 24, and that will include a qualitative, quantitative and CBA cost-benefit analysis elements.
Okay. And can you confirm the local courts, is it just up north that it's run, or where is it located currently? Is the program offered?
Merit?
Yeah.
It's in until January 2023, 55 courts offering drug treatment, 7 courts offering alcohol and drug treatment. So since January 2023, the service has been expanded, and it will be expanded between now and 25-26, which will result in alcohol and drug services being available at 30 additional New South Wales local courts and 10 existing drug treatment sites being enhanced to accept alcohol treatment referrals. So by the end of this expansion, merit will be available at 92 New South Wales local courts. So that's 45 drug merit and 47 alcohol and drug merit sites. So reaching 93% of eligible clients across the state. I can certainly provide those locations on notice.
That's fine.
And in relation to the expanded drug court, in terms of the proposed, the expansion, expanded within Sydney to the LGAs of Bayside, Canterbury Bankstown, City of Blacktown, City of Campbelltown, City... I can read all this, all right. It's a long list. Do you want me to keep going or provide it on?
I'm happy. Are you happy to take them on notice? Yeah.
I can read them now, but
No,
it's going to take 5
fine.
minutes.
Yeah,
Okay,
that's fine. Do you have any information about the wait times for the CBD and the Parramatta drug courts?
Look, I could attempt to answer that. I prefer, for the sake of accuracy, if I may, to come back with a proper response.
And also the number of people who can be assisted at these two, both CBD and Parramatta.
I may have that. Just give me a moment. Yeah, so yeah, with the expansion, it will be 160 participants per year in Sydney.
And do you have the figure for currently before expansion?
No, I'd prefer, if I may, to take that on notice.
And then also the number that can be assisted through Toronto and Dubbo.
So the
Dubbo,
capacity,
you said the capacity was 80.
that's the capacity at Dubbo, yeah.
Oh, sorry. Toronto.
Toronto, I don't think we have Toronto.
No, that's fine. I wasn't sure if you were
Sorry.
looking or waiting for me.
You thought it was a very considerate response. Good.
The other question is if there's a difference, or if you've got the information, the difference between wait times in regional locations versus the city locations.
I think it would be wise for me to take that on notice, if I may.
I have, if this helps, got the capacity numbers for the other courts. So Parramatta sits 5 days a week, sits 5 days a week and has capacity to support up to 160 participants per year. Hunter sits 2 days a week and has the capacity to support up to 80 participants a year. And Sydney and Dubbo we've covered.
Okay, thank you. Now, just back to merit, the merit program. What is the wait time for the merit program?
I think I'd need to take that one on notice.
That's fine. And how many people can the program assist at any one time?
I can give you the merit numbers for 2022, which was a calendar year.
Yep.
So the total defendants referred were 2,747. Total participants accepted was 1,856, which is a 67% acceptance rate. And total participants who successfully completed 1,265, so that's a 68% completion rate.
Okay. And also, just similar to the other one, do you have the reason why they're not accepted?
I'd need to take that on notice. There's probably various reasons.
Yep.
Yep.
I'm fine. Do you want? Yep. I'll come back. Oh. Do you have any real ones?
Oh, yeah, no,
Yep.
I've got some, yeah, sure. Okay. I apologise, I can't quite read I can't quite read your name tag. I apologise.
I'm Paul McKnight.
McKnight, Mr. McKnight. We could pick up the conversation we were having a little bit earlier in relation to the stakeholder consultation in relation to the conversion bill. I found that
Yes, indeed.
very interesting. Just wondering, so you were talking that this wasn't a public consultation, it was a targeted consultation where you identified the stakeholders. And what were the factors that led you, how many stakeholders were consulted?
So the total consultation, I think, as the AG indicated, was about 150.
115?
Yeah, 150.
150, and they were groups or individuals or?
They would have been groups, like state peak bodies and
Yes.
and groups of that nature. Can I say that the stakeholders were identified by the joint working group? So that was a working group established by government consisting of DCJ and health advisors.
And what was their process to identify the stakeholders?
So they, as I said, they thought about the key sectors involved, and they accessed the stakeholders that they knew existed.
Mm-hmm.
Other stakeholders, though, were nominated by that initial cohort, so there was a kind of rolling process of identification.
Okay.
And so the stakeholders that were first talked to identified others who had relevant expertise and interest in the reforms, and they were also consulted in the consultation process. There was a process by which we sought written feedback from those stakeholders, as well as a process of face-to-face consultations.
And you're happy that all the relevant stakeholders were captured in that process?
I'm satisfied that is a large number of stakeholders that capture the interests that are at stake in this in this area, yes.
And it would have included academics working in the space?
Absolutely, academics working in the space.
From universities, from think tanks, where would they have come from?
From everywhere. I think...
From what sort of disciplines were the academics? Were they medical academics? Were they psychological? Were they sociological?
They would have been academics working in related fields that have an interest in conversion practice.
So
I don't have
could you
the
tell me what the
disciplines.
related fields are?
They could have been any of those fields. Can I take on notice the disciplines?
Yes, that would be great. I'd appreciate if you could take on notice of that. Yes, no, thank you very much.
Yeah.
It would have been social welfare groups?
Give me just a moment.
Sure.
So what I have in terms of the sectors and groups consulted, so as we said, academics and researchers, and I'll get you some more detail about the disciplines.
Thank you.
Cold community organisations, education sector, including those representing religious educational institutions.
So for public education, who would that have included? Would it have been the unions or the department or principals or...?
Again, I'll need to take the detail on notice.
Thank you.
It would have involved the department, undoubtedly.
Okay.
Faith community organisations, including all the major denominations.
Okay. With respect to faith communities, did it also include specialist ministries who work with people who are LGBTIQ?
Undoubtedly.
Okay, why would they not have been included?
Sorry, I didn't. Yes, I imagine they were included.
Okay,
yes.
so courage was included?
I don't know the answer to that
Could you
question.
take that on notice? And if they weren't, could you perhaps indicate why they were not?
I'll take that on notice.
That'd be great, thank you. Sorry, were there other groups that you were...
Health sector, legal sector, LGBT...
So legal sector, Law Society, Bar Association?
Yes.
Okay, yes. And health sector, Department of Health or private doctors
Health
groups,
providers,
nurses
yes.
groups?
Doctors with an interest in this area who work in the
So
field.
how were the doctors with an interest identified?
As I said, through the process of the working group coming to a view,
Okay.
so that involved health people plus the stakeholders
I
indicating
suppose
who
I'm
else.
generally curious, given that there's this sort of fairly circuitous process of trying to identify people with an interest, why there just simply wasn't a public call for, if you're interested, we'd love to hear from you, which is, I think, a more typical process in government.
Well, some of those questions are obviously questions for government, not for officials. I would say though,
What
that
advice would you have given to government about the way in which the consultation should be
again,
structured?
questions for government, not for officials. What I would say.
Sorry, the question I have is, what advice would you have given to the government about the way in which you think the consultation should have been structured?
We would have given government a range of options to how to consult with community on this.
And what factors would have weighed more heavily for you in terms of an open public consultation or a limited targeted consultation?
What I would say about this consultation in particular...
I'm sorry, is this an answer to the question I just asked?
Yes.
Great, thank you.
So this consultation obviously concerns a matter of great sensitivity and personal sensitivity.
Yes.
And so the confidentiality of the process, I think, was in part sought to facilitate really frank discussions and contributions from the stakeholders.
So do I understand that, as you telling me in answer to my question, that the advice that you gave to government was that it should be a confidential process to protect people who might wish to provide evidence?
I'm not going to canvass what
Sorry,
advice
the
we're providing
question I
to
asked
what
is,
policy
what were the
advice
factors that led to the advice?
I'm not going to canvass the
Okay.
policy
Thank
advice
you.
we provide
Yes.
to ministers.
Okay. And so you're saying that it was to do with the sensitive nature of the legislation that's been contemplated, that it should be a confidential consultation?
As I said, I'm not canvassing the advice we provide to ministers.
No, I'm just paraphrasing your question to check that I've
Point of order.
understood the answer that you gave.
Yeah, point of order, Chair. Look, I've been listening intently to this, and
I think it's absolutely clear that the honourable member, through a series of questions and flattery, is trying to inveigle this member from the department into providing commentary on government policy, which is clearly out of order, Chair.
Well, commentary on government orders, policy, is out of order, but I'm sure Mr. McKnight?
Yes.
I'm sure Mr. McKnight is experienced enough to know that his comments don't fall into that category. So, good luck, Ms. Carter.
Thank you. I believe my time has expired.
I'm not taking any questions, and there's nobody else here.
All right, then.
So go for your life.
You keep going.
I might keep going then, Mr. McKnight. Thank you very much.
Long after.
Well, I'll sacrifice my time. We'll finish early.
In terms of the groups, so you said LGBTIQ groups. Did that include the LGB Alliance?
I don't have a list of
Could
the
you take that on
stakeholders in front of me. Absolutely happy to take on notice
Yeah, no,
what we can provide to the
I would appreciate
committee.
that very much. When can we expect an exposure draft?
I think the AG covered this issue this morning, and I think I'd refer back to his answers.
Perhaps you could remind me. I don't immediately recall those answers.
I think that's as much as I can help you with on this question. I'd refer back to what the AG said this morning.
Okay. Can anybody else help me with when there will be an exposure draft of this legislation?
I don't know.
Okay.
Sorry.
Okay. Would you normally expect with something as significant as this that there would be time for, there's been a small targeted private consultation, that there'd be an opportunity for broader public consultation about this legislation?
I think I'll refer back to the attorney's answers this morning.
Did the attorney address that
Look,
question?
point of order, Chair. I think the issue here is one where the Attorney General earlier today, I think, gave a time frame for when this will be introduced, but also said it's subject to a cabinet decision. And I think these questions are really trying to elicit information about the cabinet process, and therefore the question's out of order.
Yeah, I uphold the part.
I'll move on to something
Point of order.
Thank you. If the government is introducing its own legislation instead of supporting the Greenwich legislation, it would suggest that the results of your stakeholder consultation have confirmed that there are issues that stakeholders raise, that they would seek legislation that has a different form to that proposed by Mr. Greenwich. Is that a fair summary of the stakeholder consultation?
You are drawing me into policy issues here that I cannot go into.
Will there be made public any summary, survey, overview results of the stakeholder consultation?
Again, that's a question better put to the Attorney General.
So if the point of the stakeholder consultation was to gather views to inform good legislation, but those views are never made public, how do any of the stakeholders even know if their views were reflected in the final legislative product?
Point of order.
Point of order.
I think that in substance is seeking an opinion on a government policy which it would seem is to not necessarily make these things confidential. So it's not a matter of being sure.
Yeah, I uphold the point of order.
Thank you. I have a number of questions about this because I'm fascinated by the whole process. But perhaps I can just ask some questions and you can tell me whether you're able to answer them or not.
More than happy to do that.
Thank you very much. So, as I understand it, for example, stakeholders such as the LGB Alliance have raised concerns about the fact that the currently exposed version of the Conversion Practices Bill extends to transsexuals as well as to gay conversion practices. Were these stakeholders likely to be heard in the government's draft?
I'm not sure what you're asking me
Well, I think it's very clear. A number of groups, for example, probably the leading group advancing this position is the LGB Alliance, and they are concerned that the Greenwich Conversion Bill covers both gay conversion practices and transsexual conversion practices, and they believe it should deal with gay conversion, not transsexual. They're an important stakeholder. I'm wondering if those stakeholder views are one of the reasons that the government draft is different to the Greenwich draft. Have they been heard in the government draft?
You really are.
I think that's going into cabinet process.
I uphold the point of order.
Okay.
Perhaps you
Then-
might want to submit those in writing and get no comment, no comment, no comment on all of them.
I'm very familiar
Save us
with
the time.
That's right. Yeah, look, but perhaps
We're not
I
here to
will
help you.
stop asking these
Yeah.
questions because it seems that I will not be getting answers. But I'm fascinated by this process. Yeah, thank you.
I am. I'm happy to go
Well,
back
I'm
to...
fascinated by the process too, but you're not getting any answers.
No, this is right. This is clear.
I want to go back to merit program and drug courts. So just on in relation to the drug courts, just one question in relation to whether or not you have a breakdown of the number of Aboriginal people that have gone through each of the courts.
We can do that. I would prefer to take that on notice.
Fine. And the same in relation to the merit program. How many people, how many Aboriginal people have gone through that program?
Yeah, I'll take
Okay.
that on notice, yeah.
Now, just in relation to, I think you said the merit program was operating in 92 local courts.
Just double check. I think
Write
I
that down
said
right.
Will be.
It will be.
What was the determining factor of where the program will be rolled out to?
I think looking at the sort of data and analytics that we get through Boxer and where the need was across the state, but I'm happy to take that on notice in terms of the methodology, but I'm pretty sure that was the approach.
Was funding a factor at all?
What means we could only roll it out to 93% of the state, so obviously that was a factor, and then looking at the areas with the most demand.
Yep. And then when you do the evaluation, that will be across all of the courts or limited?
Yes.
Yep, good.
Except for the ones, as I said, there's a number 2 rollout,
Yep.
so the ones that are currently operational.
Yep. The analysis of the merit program by the New South Wales Bureau of Crime Statistic and Research notes that the relatively short program compared to other diversion programs, and I understand it's only, the merit program's only a few weeks or a couple of months, is that right?
I think it's a 12-week rehabilitation program.
The new drug policy and the health interventions, do you know how long on average those interventions would be, the health interventions would be?
I'm not sure if that might be a matter for New South Wales Health, but happy to take that on notice.
And also if there was any evidence provided when the decision was being made or the advice being provided about the effectiveness of a shorter period of time for the program. So basically looking at the merit program, which was on a short sort of 2-month, 3-month program versus longer health interventions, whether or not any evidence was provided.
Okay, I'm happy to take that on notice. It was, as I said earlier, evaluated in 2009, so they obviously looked at what worked, what didn't work, and then tailored it for, the extended version, but happy to take that one on notice.
That's fine. The press release of the 10th of October, which announced the drug diversion and health intervention policy, notes the New South Wales Police will retain their discretion in all cases to charge a person and proceed to court. Are there any guidelines being developed to indicate situations in which the DPP will proceed with prosecution?
So under that program, it isn't the DPP that would ever prosecute those matters, the minor possession matters that would be for the police to prosecute in the local court. The police will operate under their own internal guidelines for that program, and they will be in their standard operating procedures in the normal way.
The press release also notes that the drug diversion policy is evidence-based. What was the evidence that was provided?
So there's a range of issues that evidence goes to in formulating this program. Some of it is to do with the kinds of outcomes that people who are being charged with possession are getting in court. So a large number of them were getting convictions with no further penalty. So nothing, in fact, was happening in relation to that person's drug use. Under this program, what happens is that they are referred to a health helpline, and that counselling has a health evidence base going to its effectiveness in changing behaviour.
Okay.
Could I just ask a quick follow-up? So the health helpline that the offender rings, the intervention takes place on that helpline?
Principally, yes, in relation to that person, but there's also an assessment of that person's needs. So if in conversation with the person it is discovered that they have higher needs, they may be referred to further community interventions and further services in the health system.
So everything initially is telephone based?
Yes.
And are you familiar with the phenomenon of impression management?
I'm not, no.
Impression management is a major factor, especially in psychiatric health areas, and it's particularly pronounced with telehealth and telephone health, where the person actually, because they're not in the physical presence of a health practitioner, can manage the impression that they provide. Has there been any work done to compensate and accommodate for drug offenders who might be managing the impression that they are providing to the person on the other end of the phone?
I think those questions need to be referred to health.
And Justice has no concerns that there might be perhaps inappropriate tailored interventions being offered as part of a CIN because of impression management?
I think you're leading me to
I'm asking
to
you a
an
question.
answer.
I'm asking you a question. I'm asking you a question.
I mean, as a general matter, in Justice, we are concerned to ensure that diversion services are adequate and address the needs of the person in question. We work with our health colleagues to ensure that those diversion services are properly framed.
And have you had any conversations with your health colleagues about how they are compensating for the well-known phenomena of impression management?
I haven't.
Is
no.
that something that Justice is planning to do, or could perhaps you take that on notice so that we could get information about that?
More than happy to take that on
That would be
notice.
lovely. Thank you very much.
Yep. No. I just want to move on to a couple of questions in relation to coercive control. Coercive control includes seeking to control the choices of others. The New South Wales Government's website, and I've said this before, indicates that coercive control includes exploiting a person's medical condition to make decisions about their care, to disempower or control them. Voluntary assisted dying laws commenced in New South Wales on the 28th of this month. Has the Implementation and Evaluation Task Force for Coercive Control considered the legal ramifications of two pieces of legislation interacting?
No, we have not.
No. Do you have plans to do that?
The voluntary assisted dying laws, obviously that they were developed in the health portfolio and a matter for health to comment on, but there are very significant safeguards in those laws to ensure that what is happening in a way that is voluntary. They are, they're significant.
I think the question still remains, have you thought about the interaction of these two laws, and are there plans to consider it?
What I'm just looking at, if I may say, is so the purposes of the task force, effectively the terms of reference set out in section 54, subsection 3 of the Crimes Act, I think my test of what the implementation task force would consider would be about any matter raised falling within the envelope of that statute as it's drafted. It would need to satisfy that test. I'm happy to see whether the task force within the parameters of the drafting could at least look at that issue. There is a health representative on the task force, so if I can, in a sense, take that and consider it, and I'm happy to provide advice back to the committee.
Grateful, thank you.
That's fine. In relation to the officers of the DPP and coercive control and the implementation of it, what stage of the training of the office of the DPP?
There is a... Yes, I can answer that question. So the DPP will, and I will answer your question, I just need to do a bit of a deep dive into a note here, will deliver coercive control training for all legal staff and to witness assistance service staff across 10 offices, including regional locations. That training will be a combination of face-to-face seminars and online skills training. The training will feature sessions delivered at the key office of the DPP, annual in-person training events for solicitors and Crown prosecutors, including the end-of-year solicitors conference in December 2023 and the Crown prosecutors conference in the first half of 2024. There'll be separately an ongoing online delivery of that.
Okay, so by the mid next year, everyone
Yes.
would have been provided training.
Yes. And I believe my colleague from Legal Aid can supplement or correct my response.
Supplement, Mr Secretary. Legal Aid has received some funding from the New South Wales Government to deliver coercive control training across the sector.
Okay.
And we're consulting with the ODPP and the police to make sure that our training modules are aligned and consistent with one another, so that our training will be rolling out also at the same time.
Okay, oh good.
Yep.
And also, what stage is the training for New South Wales Police at?
Yeah. So can I, in relation to the justice component, just at a high level indicate there are plans in place for police, the Judicial Commission, as has been indicated, the Director of Public Prosecutions or the Office of the Director of Public Prosecutions and Legal Aid. The police training is a 3-phase training package with the which has been, first phase of which has been implemented online to 22,000 police staff. The second phase commenced in June of this year, comprising face-to-face training of specialist police officers and identified select operational police, including domestic violence officers, detectives and investigators and police prosecutors, and that training being developed in collaboration with domestic and family violence specialists focused on recording and responding to coercive control, collecting and recording evidence, prosecuting coercive control offences, and the complexity and nuance within different communities with a focus on First Nation communities and culturally and linguistically diverse communities. And there'll be a third phase to form a training package to be delivered in the Constable Development Program, and that will commence in June 2024 and run for 2 years through to June 2026.
Mm-hmm. Okay.
I can just add to that, Mr Tidwell. In terms of phase 2 of the police training, police report about 1,200 police have already undertaken the face-to-face training in sort of phase 2.
So I understand definition of coercive control will be inserted to the Act February next year. Is that correct? Come into effect.
Yes.
What percentage of, I suppose, DPP and also police force will be trained by the time by February or end of February next year?
Look, to respond to that, I would need to do some maths. So I've got police numbers here. I don't know what the percentages are. DPP, similarly, I'd want to give you an accurate answer to that. If I can take that on notice, happy to do so.
Yep, that's fine.
And just if I can add, it's to be introduced by the end of June.
Oh, okay.
Not February.
Oh, is
Thank
it?
you.
Yeah.
Not February. Thanks.
Yes.
That's fine. 40 seconds.
Yeah. This is your time for your big question. 30 seconds.
Okay. On page 8.8 of the 2022-2023 outcome statement, budget paper number 2, it notes that the long-term increase in the number and complexity of criminal lodgements is the primary challenge facing this outcome. Is this still the primary challenge for the Department of Communities and
Sorry,
Justice?
I
sorry.
very rudely was just
No, apologies.
my colleague here.
Got 2 seconds now.
Sorry.
The 2022-2023 budget papers indicated that the long-term increase in the number and complexity of criminal lodgements is the primary challenge facing the outcome. Is this still the primary challenge for the Department of Communities and Justice?
The primary outcome of the department.
The primary challenge facing the department is the long-term increase in the number and complexity of criminal lodgements.
Oh, it's one challenge.
Right.
I would say one challenge
One
of the.
One challenge among many by the look
The
of what you're saying.
DCJ is a hydra-headed, complex, multifunctional department, as I think you know.
Thank you.
Over to you, Ms Mahay.
Oh, thank you very much. Earlier, the Attorney General was asked about whether there was any work being undertaken with respect to the treaty within the department. I just want to confirm if that's the case. Any kind of preliminary work around a potential New South Wales treaty?
Not of which I'm aware. No. No.
So that no
No.
work
No.
whatsoever
No.
undertaken by the Attorney General. Well, that's one good response. Can I, a couple of things I just want to clarify, just so that I can put it on record and not have to submit some supplementary. I wanted to just double check with the anti-discrimination review being undertaken by Tom Bathurst, what the final costings on that. You may not have the final costings, but there may be a rough cost the department has already earmarked with respect to what this review will cost in commissioning both Mr Bathurst but also any ancillary staff or additional staff. Is that the case?
So that would equate effectively to the funding. If we were to
Sorry, I'm
provide
having
you
trouble
that-
hearing you now.
I
Sorry.
apologise. The Law Reform Commission of New South Wales is funded. That is probably their most substantial piece of work at the moment. It's the main reference. We can take that on
Any
notice and come
staff,
back.
though, being from the Attorney General's department, any staff supporting the Law Reform Commission
Yes.
or Mr Bathurst
Yes,
throughout this
absolutely.
process? That's what I
Yes.
just want to
So this-
confirm.
the-
And what cost that's
So
coming
the
to.
Law Reform Commission has a long-standing staffing component.
Separate, yes.
No.
I'm just saying. Okay.
It is
yeah.
within that staffing component that the Law Reform Commission is completing
Have there been
its
any
work.
additional staff put as a result, or any additional resourcing as a result of undertaking what is a pretty substantial review? It seems.
Not to my knowledge, but I'll take on notice whether we have within the policy area of my area shifted people around to
Yes, if you could provide
accommodate
that
that
on
priority.
notice, that would be.
Yeah.
The attorney
So-
indicated this morning, Mr Halick, that that Kate Eastman SC has been appointed.
Yes, I heard that. Yes,
Yep,
yes,
got it.
yes.
So
Okay.
she's been appointed as a part-time commissioner.
Right.
There are 3
What
commissioners.
was her previous role? My apologies.
She's a barrister.
a barrister.
Barrister, right.
There are 3 commissioners currently of the Law Reform Commission. Mr
But
Bathurst.
she's been put on specifically just for this review. So I understood that. Was that right? Or?
She's participating in all the work of the Law Reform Commission. There are only 3 commissioners. The
Yeah.
3 commissioners together undertake the work of the Commission. Mr Bathurst is the chairperson and the other 2 commissioners also work on the
But
two
this will be the
reference.
bulk of their work, you would have thought.
It's the
right
most
now, I would
significant
imagine.
project they have at the moment.
And
yes.
can I, and it may not be available, and I'm not asking for the date that it might return to Parliament, but I am asking, is there a rough date or timeline or time frame that they might indicate, the Law Reform Commission could indicate where they think their work will be complete?
So the terms
If
the terms of reference for the Law Reform Commission do not provide
No,
it
it
with a
didn't specify
due
time.
date. I understand the attorney has indicated that he wants to move this review on swiftly, and I think he talked about a time frame this morning. The Law Reform Commission itself hasn't advised on a time frame, and it's obviously a matter for the Commission to determine its process and when it reports to government.
Okay. And can I ask about the Conversion Practices Prohibition Bill, if that's what this bill is going to be referred to or called? I'd like to know the amount of resourcing and specifically staff resourcing, and potentially if you can break that down into a cost associated with the work required to support this bill being prepared for Parliament by the AG's office. Is that possible to get a breakdown?
The AG's office or department?
Well, the department.
Yeah.
I would like the AG's office too, but I think you may not be able to provide that for me, but you might be able to provide how much support resource-wise has come from...
I would say the policy area in my division is supporting this work. It supports...
Well, how many staff does that involve? How many full-time staff does that involve?
on this project.
And since when did they start? I mean, is it since April, May? Well, no, it would have been about June, I think, June, or when did they first indicate the work?
So the policy area in my division is a reasonably large area. It's 80 odd people. It supports the work of the attorney and other ministers that DCJ supports in their policy and legislative programs. We move people around projects and support the range of work that government
Okay, well, with
needs
that 80,
in
you can give me a rough ballpark figure.
I would need to
how many
take-
maybe were allocated towards that particular legislation.
I would need to take that on notice,
Yes,
but
sir.
I would say we do not break down policy projects in that way.
Okay. Were any new staff put on as a result of this legislation, specifically to work on this legislation?
No.
No. Thank you.
Could I ask about the Stewards Foundation of Christian Brethren Act? It's an act that the Attorney General has responsibility. I'm just wondering whether there's any...
Can I ask about that?
Whether there's... yeah.
Very good research.
Yeah. How's it going?
I'm quite excited by this question.
No, it's so
18 notes do not cover that statute.
Yeah, have you got... We need a note. Okay, well, no, look, it's fine, but it is one of the Attorney General's Act, and I wrote to the AG recently, and I was just... My question was, is there any departmental expertise around the administration of that Act and some of the problems that are experienced in the community around the brethren, the Christian brethren?
So you've written, we will
Okay.
pursue that
All right,
response.
thank you. I'd just like to, if I can, just put on the record that there's some, on the face of it, there's some really affected, there's some serious impacts that are happening on members of the community, quite vulnerable members, and it seems that this legislation is actually empowering the, I'm not very good on these kind of organisations, but the actual brethren churches, because of the power they have under this legislation, people are being impacted in ways that I don't think this Parliament would ever have contemplated when that legislation was enacted. But yeah, it's in the letter. I just wondered whether there was any expertise within the department around the Stewards Foundation of Christian Brethren Act. Thank you.
What year is the Act?
1989. Yeah. It's
You tried to flicker.
no, it wasn't. It was a genuine. I was just wondering. It's one of those acts in the long list of
It's
acts.
not a question we anticipated today.
No.
The system has failed badly.
No, that's right.
Sunday's coming up.
I thought it might have been 1889. by the
Yeah,
sound
well,
of it.
this is right. This is right. But no, serious impacts of people losing their assets and their capacity to control their own lives because they, at some point, found themselves involved in this found thing. Can I ask about community legal centres and the current? My understanding is Legal Aid administers the funding from for the CLCs from various sources. What is the proportion of New South Wales funding for the community legal sector?
So for 2023-2024,
Yep.
The state component is approximately 15 million. The Commonwealth component is rounding up to 22 million, and approximately 2.5 million comes from the Public Purpose Fund, the New South Wales Public Purpose Fund.
Right. And is there at the moment what is the length of what is the term of funding for CLCs? Are we still in those kind of short periods, or have we got what kind of contracts do we have with them?
We have a service agreement with each CLC.
Yep.
Funding has generally been allocated up until the 30th of June 2025, which is when the National Legal Assistance Partnership Agreement that we are currently governed under comes to an end.
And so how long was that national partnership agreement?
It's a 5-year agreement.
Okay, and it's coming up in 2025.
That's right. Yep.
Right.
And it's currently being reviewed at the moment by the Commonwealth and the state attorney generals.
Right. And is there a view at this point in time? Does Legal Aid put forward on behalf of CLCs? Does it put forward a submission about the health of the sector or the needs of the sector?
Community Legal Centres New South Wales and Community Legal Centres Australia puts forward submissions to both the Commonwealth and indeed has done so to the NLAP review on behalf of its membership. Legal Aid New South Wales has also put a submission in to the review and also put submissions into the Commonwealth Government about the needs of legal aid commissions and essentially the legal needs that exist within our individual states and territories and the Commonwealth more broadly, so that we speak to the unmet legal need that is in New South Wales, but also more broadly around Australia. And there are parts of our submissions that are very much aligned with the submissions that are made by CLCs as well.
And
in terms of a shared view of what that unmet legal need is.
Thank you. And at the moment, what is the snapshot in terms of the health of the sector and unmet legal need?
I think that's a question that is really quite difficult to answer in the sense that there is obviously a lot more legal need that is not being met, that could be met, but the extent to which we're able to meet that legal need is a question of priorities for government, and clearly the NLAP review is going to provide us with a lot of great information about how our funding should be allocated and prioritised and targeted. But I could say on behalf of Legal Aid New South Wales, what we do is pay very close attention to where we see the unmet legal need is, and we target our resources accordingly.
And at the moment, where are you seeing the biggest, the area of most unmet need?
Again, that's a very big question, and I think it best answered by the NLAP review, because I think that review process is bringing together a lot of data, more data than I would have access to, or that individual organisations have access to. So I would defer that answer to the NLAP review, because it is going to provide us with a very good snapshot of where that unmet legal need is.
And so when will that review be completed?
My understanding is that the reports are going to the Attorney General's around the end of the year, around December, January next year.
Next year?
Yeah.
Yeah.
Yep.
Yeah, go for it. Yep.
Yeah. I just thought I'd jump in because I do want to ask about community legal centres. And look, I was on the another committee the other day when I had an opportunity to ask about the Children's Court, and I know that may not be able to be answered right now, but guardianship orders, there was an act that amended guardianship orders around the issue of consent and parental consent back in, I think, at the end of 18, and it came into effect in 2019. And I asked questions in relation to the Facts Minister yesterday about whether there'd been any particular review around the changes from that particular legislation, which was proposed at the time by Prue Goward, with respect to, because there were the community legal centres at the time wrote in as part of that review of that bill, wrote in their particular concerns around alternative dispute resolution processes and the fact that parents might consent to these guardianship orders without having access to full legal advice. I want to know whether there'd been any kind of work done since the start of that legislation. I asked specifically what the numbers of guardianship orders had been over the course of the last 4 years as a result of that change, but two, I wanted to know if there'd been any reviews undertaken by community legal centres or indeed by anywhere across these departments about the impact of the change of that act in relation to opportunities for parents to be able to access legal assistance as those very dire decisions were being made about their children and guardianship orders. Sorry, I can take all that on notice, but I know that there was 78 organisations at the time raised concerns about parts of that legislation, and most of the matters were around facts, but one specific area was around that lack of access to legal support for parents who might not be fully cognisant of what was actually being proposed before them in losing their children with these guardianship orders. So I want to know if there's been any review undertaken in the 4 years since that legislation took effect.
I'm not aware of any review. I can say...
Has community legal centres raised it since then? They did raise concerns at the time. I'm not sure if there's been any follow-up.
I'm not sure either. I'm sorry. I can tell you though that...
sorry, because I don't think the person who normally is who has sort of Children's Court, who manages that.
Yes, so...
And they're not here. I understand that, yes.
For personal reasons.
No, I
Karen
understand
Wallace,
that. So that's why I thought if I could
Yes.
put on notice, perhaps they might be more aware of whether any concerns have been raised around those guardianship orders in the way that they're now
by
being
the
administered.
CLCs.
CLCs and generally any of the individual organisations that normally play a role throughout the hearing in providing assistance. It may not just be the community legal centres. Legal aid might be involved, or it might be other organisations in the facts area, the NGOs that are involved as well.
So we did, I think, out of yesterday's estimates, agree to take something on notice.
Yes,
from
I
memory.
asked a similar question there,
And
so I just wanted to flag
I will
here
make
as
sure
well,
we
yes.
bridge these. I will ensure that we do some inquiry
Okay, lovely.
around that.
Thank you very much. Thanks.
Thank you. Just wondering about what AGs has done, if anything, to assist the ALS. I know the ALS was calling out for a massive shortfall in its service funding. And yes, I understand it's mainly a Commonwealth relationship, but has New South Wales done anything to help? And what do we do to help the ALS in terms of direct funding for their services?
I'm happy to provide the funding that Legal Aid New South Wales provides the
Yeah,
ALS, if that would be helpful.
That would be very helpful, thank you.
We provide $1.8 million a year in relation to work they do for the early appropriate guilty plea scheme, EAGP reforms.
Yeah.
We also provide $350,000 a year to employ solicitors in care and protection roles. And we've been providing $60,418 to continue to coordinate 2 regional cooperative legal service delivery model areas or regions.
And do you know what percentage of what you give is of their overall funding?
I don't know that.
No.
I'm sorry. Yeah.
Is there any view that the New South Wales government could be providing ALS more support? Is that something that's been canvassed within the department at any point in time in the last 12 months?
I think there is if I can say it, a caution around any cost shift from the Commonwealth. If I may, through the remaining time, I may wish to supplement my response now. I just want to check the funding. I would make the general statement that the work of ALS is obviously very important and highly valued. I do speak with Carly Warner frequently and acknowledge the vital role of Capo. But if I can just perhaps come back on the question of the relationship with the financial relationship with the state of New South Wales, but we would be reluctant to separately see a transfer of a shift of cost from the Commonwealth to the state.
I think that I think I would be in fierce agreement with that proposition, but I think, is it not that therefore legal aid, ALS ends up really having to suffer because of I'm not remotely suggesting that the Commonwealth should be able to cost shift, but if we're not looking at what we can do better and provide more because of, is there not some way, and does it not happen in other things, where if the Commonwealth's providing funding, you enter some sort of agreement with the Commonwealth, well, we're going to provide this extra money, but you can't, not on the basis that you would lessen your funding. I think it's more about the ALS. Are there other streams? Like clearly, there's programs that are funded.
There are, if I may just say, so in 22-23, the New South Wales government provided the ALS with over $4.6 million for specific state-based projects, and I can list them: the early appropriate appropriate guilty plea service, participation in the Koori Youth Court, tenancy advice services, and care and protection services. And additionally, in 22-23, the New South Wales government committed around $28 million over 4 years for the ALS to deliver community-led initiatives to support the Closing the Gap agreement.
Great. And so I think really what I was going to is there a plan or a view that those programs could be increased in their funding as time goes on? Is that something that you're constantly reviewing?
I could perhaps help with that answer as well. So under the National Legal Assistance Partnership Agreement, I can advise the committee that the ALS will receive in 23-24 $20.145 million, which is an increase from last year. Last year's allocation was $19.73 million, so it's a slight increase from last year. And that again is part of the review of the National Legal Assistance Partnership Agreement, the allocation to Aboriginal legal services across the country.
Okay, thank you. Right, whose turn is it now? You go.
Over to you. I actually might begin with a question to Mr. Thomas, could you update us on the Closing the Gap priorities and how things are tracking? Notice you said much.
Sure. Specifically in relation to the
AG's
priority, which is the target related to imprisonment.
Yep.
Unfortunately, the number of Aboriginal people in jail has increased
Yeah.
this year. That increase is 100% remanded. So the entire increase is the number of people being remanded. The likelihood of Aboriginal people being sentenced to prison, so people being sentenced following a conviction, has actually declined over the last 2 years. So the sentence numbers are declining, however the remand numbers are increasing.
Mm-hmm.
The department and its partners have been working on a very comprehensive program of work that focuses on 5 areas to try and reduce this particular target. One is greater levels of diversion, and that's being pursued by the expansion of the merit program, the expansion of justice health, mental health nurses to divert more people, and setting specific performance targets in those for Aboriginal people. So the merit program, for instance, now deals with Aboriginal people at the same rate at which they appear in courts. There's been a significant increase in the number of people getting into that program, as well as doubling of the number of Aboriginal people in the drug court in the last year and a half. Those mental health nurses, which are being expanded across New South Wales, are diverting Aboriginal people in the courts where they exist 3 times the rate at which they're being at which they would be diverted in courts without those. So that front-end diversion activity is bearing some results. The second part of the strategy is to try and make sure people appropriately get bail and maintain bail when they do get that. I mentioned there's been an increase in the number of people on remand, both adults and juveniles, and that's a significant challenge in terms of meeting this particular target. We do have a number of activities trying to increase and support bail. The Secretary mentioned the funds that have gone to the ALS to establish bail support services from the legal service. We've got a number of trials with the police around community-based bail supports, some trials with Wagga and other places around bail supports for people. The third part of the program is to try and encourage people to complete and serve sentences in the community. And as I mentioned, there's been a decrease in the number of Aboriginal people being sentenced to prison and an increase in those community-based sentences. The fourth is to try and reduce the rate at which people are breaching sentencing orders, so intensive correction orders and parole orders, and we work very closely with New South Wales Community Corrections on a range of activities to try and increase the rate at which people successfully complete those orders. And the final is to try and reduce the rate at which people are returning to prison. And as we spoke in the corrections hearing recently, there's a major piece of work corrections are doing called Homestretch, which should commence in the first part of next year, which is about better release planning for people and greater ongoing support for people once they do get out of prison to try and reduce that return to prison activity. So there's a range of activities, many of which are bearing fruit, but the challenge of those remand rates is pushing that target in the wrong direction.
Thank you. Well, might cross over to youth justice, but I'm interested to know the number of young people each year who reoffend within 12 months of participating in the Youth Justice Conference or completing a custodial order or sentence. And that's for 22-23.
I may well have it. Oh. It's going to be an ambition to find it. Would it be possible if I took that on notice?
Yeah, that's
Thanks.
Fine. That's fine. Now, in relation to the operating costs, in the budget paper number 1, which is page A5 to 11, there appears to be a reduction in the operating costs across the Department of Community Justice, and I was interested to know what the total reduction was.
So department-wide, the recurrent expenses for 22-23, 2.038 billion, and in 23-24, 2.189 billion. In 22-23, the capital component of that, or above that, is 125 million, and in 23-24, 81 million in relation to the
That was for capital.
That was, yes. And I did, for the total legal function, so the subject of this committee today for courts, tribunals, and I can itemise these, but DPP, legal aid and other things, 880.6 million dollars.
Mm-hmm. And what was the, how did you receive or achieve, I suppose, a capital reduction from the 125 to 80, I think it was 81?
81, Can I take there? I think there was work undertaken last year. I just want to check, and we'll try and come back very quickly now on what that work was. There was a reason, but it has reduced in the for 23-24.
Yeah.
Sorry. Could I just ask that courts tribunal figure that you gave us?
Yes.
That's this year's figure?
It is.
Increase
23-24.
or a decrease from last year?
It's an increase. In terms of that figure for 22-23, I would need to take that on notice, but I can certainly obtain it.
And just to confirm, there's been no programs that have been reduced or had their funding reduced?
There have been no programs or frontline services that have had their funding reduced. Sorry, that is not accurate. I have overlooked one thing, which were the community legal centres.
Yeah, and the Graffiti and Crime Prevention Fund.
Yes, and
I had a feeling they might be.
Not the community legal centres.
I'd named the wrong thing. What were they? Community justice
centres.
Community justice centres.
Okay.
Community justice
And
centres.
can I say the
was
manner
there
in which
another program that was mentioned? Sorry, Ms.
yes, the
Campbell?
graffiti program and the community justice centres over the years have moved to effectively be, and I look to my colleagues here if they can help me, or maybe they can't, but my understanding is a lot of that service is now provided online.
I can't help it.
Yeah, I'm happy to.
But do they still have the kind of mediation function that they used to have? Is it
legal aid?
No, the community justice centres. Like that was the place, particularly for those kind of neighbourhood disputes and all of those.
Can I come back on that?
Thank you.
And I may try and do it this afternoon.
Sure, thank you.
Thank you. And then the other one was the graffiti program.
Yeah, that finished in June.
Last year, well, this year.
June this year, yeah.
Yeah, thank you. Yes.
I note in budget paper number 3 at page 4-8, there's an allocation of $871,000 to improve local court capacity. Which local courts are being improved under this allocation?
I will need to take that on notice.
Thank you. And what's the expected impact on local court operations of the drug diversion policy?
I will need to take that on notice.
Okay, all right, because I just draw your attention to one of the reasons the Attorney-General advanced for it was to reduce pressures on the local court system and free up its resources to deal with other issues.
Yes.
So it would be very interesting to have that. Will any savings in local court costs which arise as a result of the drug diversion policy be directed towards further resourcing drug diversions, or will it just be diverted into other areas in the department?
I'm unaware of it being diverted into.
Can I assist with this one? So we expect a few, I think it's in the realm of a few thousand matters, or possession matters.
Sorry, could you talk up a bit?
We expect something in the realm of a few thousand matters to be taken out of the local court in drug possession proceedings.
Could you give me an indication of size, so a few thousand?
Can
out
I?
of how many?
I will take the precise figure on notice
Sure.
if that's okay.
No. I'm just trying to get an idea of scale. That's
That
all.
will go to relieving pressure on the local court, which, as you know, is the busiest court in Australia, and has a number of challenges in ensuring that timely service is provided. So that's how that will play out in terms of resourcing. The money. There is no money saving here. It's an efficiency in terms of local court operation, and it should improve the standard of service to people using the local court.
And will that form part of the review of the drug diversion program?
Yes.
Okay. And when and that'll be reported on?
So there will be a Boxar evaluation. Yes.
So Boxer will do the review of the drug diversion program?
There is a Boxar review of that drug diversion program,
Okay,
but I
when's
think
that
the minister outlined this morning.
When was that scheduled?
I'm
for?
sorry, I don't have that.
All
in
right,
front
thank
of
you.
me.
Ms Hickinson, if I may.
Thank you.
In relation to the review and reduction in community justice centres, I'm able to speak to that, if that would assist.
Yeah.
So they've been a branch of the department established to settle disputes through mediation free of charge to users.
Yes.
All initial contact with the CJCs is through a call centre. Mediators are contracted to conduct mediation conferences across New South Wales from government offices or private leased spaces. In 21-22, the centres received 8,237 new inquiries, with only 797 proceeding to mediation, so less than 10%. Callers are often seeking legal advice, which is not within the remit of DCJ. Moreover, the information sought by callers can usually be obtained from other government agencies or websites. Hence, there is a flagged $3 million saving beginning from the full year of 2026. So it's a forward saving, which from 26 to financial year 26 to financial year 33 would be $23.7 million. Okay.
Thank you. I just recall sitting in local courts regularly with magistrates referring people to the CJC, and curious that those numbers. Thank you.
I'll jump back in. I'm going to ask about the prison bed capacity program. I note in the this year's budget papers, 30 million or around 30 million has been allocated. However, in the 22-23, the allocation was over 77 million. What effect has the reduction, which is around 47 million, had on the delivery of the program?
Can I just say, I dealt with this issue the other day, or the Commissioner and I and the Minister dealt with it at the corrections estimates. I actually don't have that material with me, but it was dealt with during Minister Chanthethon's estimates.
Thank you. Then you've answered my next three questions.
In February of this year, the Coalition Government announced a $5.1 million upgrade of the Port Macquarie Courthouse beginning April this year. Is that upgrade going ahead?
I have nothing in my briefing that would indicate that it's not, but if I can take that on notice.
Thank you very much. Are there any planned upgrades for the Campbelltown Courthouse?
Not in the current year.
Okay, thank you. Does that indicate that you're looking at it in future years?
The matter of courts redevelopment capital is a matter for government. There's nothing that of which I have knowledge today, of which I can advise this committee.
Thank you. And how much funding has been allocated for the Parramatta Justice Precinct?
The
Parramatta Justice Precinct, how much funding's been allocated?
Do you mean for redevelopment or...
For the redevelopment, I apologise, yes.
I would need to take that on notice.
Okay, thank you. Apart from audiovisual upgrades, what infrastructure is funded under Phase 2 of the Sustaining Critical Infrastructure program? And does this include any physical upgrades to courthouses?
I would need to take that on notice.
Right, thank you very much. Okay. Then I just have a few questions. Ms Hatter, in relation to legal aid?
Yep.
So the budget includes $9.5 million for Legal Aid New South Wales to implement a new platform to make applying for legal assistance quicker and easier. And the claim is the money will allow the organisation to use the latest technology to better manage applications and support private practitioners to deliver services to disadvantaged clients. Can you explain a little bit about this system and how it will benefit the clients?
Yep, certainly. The allocation is $12.5 million over the coming 4 years, with $4.5 million for this financial year. The current system that we're operating under, it's called Atlas, and it is 17 years old. It is a very old legacy system and is really on its last legs, to be frank. And so this funding allocation will allow us to rebuild a system by which we pay private practitioners to do legal aid work. Approximately 70% of legal aid work is done by private practitioners, and it is needing a system in order to pay those private practitioners and also administer grants of aid under our policies. So this funding will develop a whole new system by which we do that, to make it easier for private practitioners to do business with us, but also ultimately easier for clients to apply for legal aid and for us to process those applications for legal aid in a very timely way. It also allows us to upgrade our protections around cyber security and privacy. So it really will modernise this very old system.
Is there a timeline for completion?
We hope to complete it over the next 2 years, between 2 and 3 years. I mean, the funding is for 4 years, and it will include implementation, of course. So work has begun. It is a big change. It will be a big change process for us as an organisation, as well as for the users of the system. So the projections are hopefully within 2 to 3 years we'll have it up and running.
Do you contemplate that it might involve software upgrades or hardware upgrades for some of the private solicitors, or you think it should be fairly seamless?
I'm hoping that it will be fairly seamless, but I'm...
In the way of IT projects, never being seamless.
Exactly.
Yeah.
But I would be guided by the experts that we have managing this project on that.
Yeah. Thank you. And I note that Minister Daley has said that 61% of legal aid clients live in regional New South Wales. This system will benefit those clients as well?
It will benefit all our clients, but particularly those clients that may not be able to come into a legal aid office and apply for legal aid. So the system that we are hoping to develop will really make it easier for clients to apply for legal aid, know where their applications are up to, and have those applications processed in the most timely fashion.
Okay, thank you. And look, my last question really, and it's a question to do with allocation, which is always difficult. But what are the criteria which would encourage legal aid to fund an appeal? And is every time an appeal is funded, especially all the way to the High Court, what impact does that have on the number of first instance matters that legal aid is able to assist?
If you're speaking about our criminal law policies, indeed all legal aid policies, they're approved by our board. We have a board of directors that is appointed by the Attorney General, and the board sets those policies and eligibility criteria for people to access those policies. And those policies govern our grants of legal aid in all of our matters, including appeals. Most of our policies have a means and a merit test, and the policies govern the kinds of areas in which we would provide a legal aid grant.
Okay,
yeah.
Thank you. Thank you. We have a number of other questions, of which I'm very confident the answer will be, I will take it on notice. So I think it might be more efficient if we actually put them on notice.
Oh, okay, no, that's fine. Thanks very much
got
for that.
Oh,
One.
One more?
Yeah,
Okay.
just in relation to, in the past, outcome statements have been provided with the budget papers weren't this year. Was there a reason?
I think you would have to ask the Treasurer.
That is okay.
I think it's something to do with Treasury. It does instructs how they.
Yeah.
I think we're all done.
I think we're finished.
Yeah, I think it's.
We're finished.
Our government likes to be
Before afternoon
transparent.
tea.
Are you happy to call it a day? Oh, you did.
No, we're going to
All right.
put everything else on
I think-
notice.
Okay.
We've got
Right.
pages of
You've
stuff
got-
that can't be answered.
20 odd
We've got-
pages of questions, but
Yes.
we'll put them on notice.
That's
No
fine.
questions on notice, thank you.
It's a Friday.
It's a Friday. And I note there was a number of questions taken on notice. The Secretary will be in contact for your responses. Thank you very much for coming. And yeah, that's it. Have a good weekend.
Thank you very much.
Thank you.
for your time.
Thank you all.
Thank you.
Thank you.